before Lordship. I Lordship, 1 week time may be given for defect removal for defect, Lordship.
Is that 2018 matter, madam?
Lordship,
It's an old matter.
1 week.
No.
Only one.
This
Only
is
1 week.
so it goes on. And what's the delay? When it's called out, Leels.
Supplemental list, old matter, item number 2.
None appears dismissed.
Item number 3.
Lord, if you may please, your lordship, I am BC Minute.
All right.
My lord, your lordship on last occasion directed the state council to take instruction that in nearby place where the petition can be adjusted or appointed as Anganwadi. Lordship, kindly see the last order 16/8/2020.
As I had to get instructions. The instruction hadn't come. As I just want to make one submission. The issue here, my lords, is that first an advertisement was issued where, my lords, the minimum age for applying for an Anganwadi worker was 18. The appellant here applied because she was more than 18 by that time. Subsequently, before, my lords, the process was completed, a revised guideline is issued where, my lords, the minimum age is 21. Therefore, my lords, the applicant has not, the appellant here has not been considered. That is, my lords, the short point, my lords. My lords, I am relying on a Supreme Court judgment, which, my lords, I'll try to, my lords, it is not on exactly grounds, but it's Yogendra Yadav. My lords may see that judgment. My lords, in this case, the examination was to happen, was a 2-step examination. There was a written test and a viva. There was no benchmark fixed for any of these written or viva test. After, my lords, the whole process is completed, the examination authority takes a decision that we will keep a minimum benchmark for unreserved and reserved candidates. Therefore, my lords, number of the petitioners here did not qualify because they did not qualify the benchmark decision. The court held that this would not amount to changing the rules of the game. And, my lords, let me, my lords, read from para 13 onward.
How is this relevant here?
That is not applicable, my
lords, my lords, there are 2 things, my lords. My lords, there are 2 things. One, my lords, the Anganwadi posts are not, my lords, civil posts. To that extent, my lords, the rigors of, my lords, of procedure that is followed for regular posts need not be followed, and which has been, my lords, dealt with in the impugned judgment, my lords. If I may take, my lords, to the impugned judgment.
So you're giving up this.
My lord, I pray one thing.
You're in the midst of quoting this, you're giving it up then. Please. You were in the midst of referring to this judgment. When I asked you a question, you've gone to some other point. Sorry. I'm presuming you're giving up this.
No, my lords. I'm extremely sorry. Where's para 13, my lords? Para 13 of the judgment. I'm extremely sorry.
How is this relevant that you're not answering?
Lords,
here, there's no question of minimum marks being fixed at all here.
No, my lords. My lords, the principle.
Changing a whole criteria.
Yes, my lords, the principle.
After the selection has started, you're suddenly saying we'll have introduced an age limit. How can it be tenable? How is it tenable?
My lords, even in this case, my lords, there was no benchmark.
This is nothing to do with age limit. This case is all about marks.
Yes, my lords.
In fact, there was no benchmark at all. So they said if you introduce a benchmark subsequently, you're not changing anything because you're introducing it for the first time. In your case, there is an age limit.
That's right, my lords.
And you're changing it. Whereas here's no minimum cutoff marks at all.
That's right.
So how are you drawing a parallel?
Well, the only thing I'm trying to impress, my lords, is that the benchmark here was also not part of the original advertisement, and which has come post the advertisement. That is the only point that I'm trying to.
All right. Then what is the other point?
The other point, my lords, relates to
civil post.
Civil post, my lords. My lords, may go to page 19.
So if it is not a civil post, you can do anything.
My lords,
that's the Article 14 principle, is it? Not a civil post, do anything.
My lords,
People with black hair will not be appointed. No problem, because it's not a civil post.
no, my lords, there has to be some reasonable nexus, my lords.
Ah.
Yes, that has to be the guiding principle.
All right.
My lords.
All right.
My lords, page 19,
All right.
the fourth line, my lords. Furthermore, it is brought to the notice of this court that the Supreme Court in the case of State of Karnataka versus Amir B and others has held as follows. The posts of Anganwadi workers are not statutory posts. They have been created in the scheme. It is one thing to say that there exists a relationship of employer and employee by and between the state and Anganwadi workers, but it is another thing to say that they are holders of civil posts. We are not oblivious to the fact that their presence in the respective villages is extremely important. So the next paragraph. Anganwadi workers, however, do not carry on any function of the state. They do not hold post under the statute. Their posts are not created.
Is there a vacancy? That is what you were asked to find out last time. You're not answering that also.
Miller's instruction I haven't received.
You should have said that in the first instance.
That is how I started.
Half an hour like this. Because again, the same question will arise. The other woman is working since 1999.
1999.
So without disturbing her, how can you accommodate also?
No, 2002, my lord.
Whatever, sir, 20 years now.
20 years, my 2000. She was appointed on, my lord, 16/4/2002.
That's right. Anyway, 20 years are over, sir.
Yes. But illegally, he has been selected, not on the basis of the guidelines or circulars applicable at that time. I have been deprived of being selected, my lord. My candidature was not taken in consideration.
So usually there's an interim order saying appointment will be subject to the result of the writ petition.
Yes.
That is not here. That's the problem.
What happened here, my lord? I am only placing. Well, there is a guideline on 86/1992 of the government.
No, let him find out, sir. He says he needs more time to find out.
Yes, your lordship.
Yeah, you say counsel for the state relied on the decision in Yogesh was Union of India 2013 14 SCC 623 to urge that since the minimum age limit of 18 years for the post of Anganwadi worker, bracket AWW, in the selection in question, for the selection in question, was not stipulated in the advertisement itself, the subsequent introduction of the limit of 21 years, even after the process of selection had commenced, would not be arbitrary. Paragraph, the court finds that the decision cited does not deal with any fixation of age limit at all. Full stop. It is in the context of there being no minimum marks fixed at all when the selection process started, and introduction of a cutoff after the selection process was underway. Full stop. It is in those circumstances that the court, in the decision cited, held that it would not amount to changing the rules of the game after the game had commenced. Full stop. The facts here are different, and therefore the said decision is of no assistance to the state. Paragraph. It is then contended by counsel for the state that since the post of AWW is not a civil post, the rigors of Article 14 would not apply. Reference is made to the decision in State of Karnataka versus Amir B, 2007 11 SEC 681. Full stop. While the said principle is unexceptionable, in the present case, the state has to put forth a reasonable justification for changing the minimum age criteria after the selection process had begun, particularly since the changed criteria ended up disqualifying the appellant who was otherwise qualified to apply for the post of AWW. Consequently, this plea is also rejected by the court. Paragraph. By its order dated 8/8/2022, 16/8/2022, Counsel for the State had sought time to ascertain if there is any vacancy in the post of AWW against which the appellant, who at present has not crossed the upper age limit of 44 years, can be accommodated.
45 years.
45 years, okay, can be accommodated.
45.
Counsel for the State seeks some time, further time for that process. For that purpose, at its request list on 21st November.
Supplementary list item number 4.
My lord, pass over the matter on behalf of state. Pass over the matter.
No, who's for the appellant, sir?
He is appearing for appellant. He is for the appellants.
Yes. He's saying for the state?
School and mass education.
Oh, school and mass education.
No, item 4,
Item number 4. Supplementary.
Sujata Jaina is the appellant.
Adambini Rao.
And you will open the opposite way.
Appa school and mass education. Appellant by kahin kuchna.
Sir, are you for the appellant, sir?
No.
No.
Then let us wait for we want to see who the appellant is. We call out again.
Item number 4. W125 of 2014.
None appears for the appellant. This entire thing.
In the last connected 2 matter.
In the last 2 connected matters, the memo is taken on record, dismissed as withdrawn. First 2 is none appears, dismissed for not transmission.
My lord, in this I'm appearing for the OP number 4, my lord. +1 and 4.
All right.
Item number 5.
Item 5 already implemented.
Already implemented and therefore the appeal is infructuous.
Item 6 also same.
6 sources. All right.
Item number 8.
Not pressed, my lord.
Dismissed as not pressed.
Item number 9.
Your Lordship, what is the item number? I don't recollect 9 or 10. There's a Shakuntala Jana. Shakuntala Jana petition.
W325 of 2016.
9. Your Lordship, item number 9.
Yeah.
Pass over.
Item number 10.
Memo is taken on record. Dismissed.
Name of Mr. Usgata Mala, OP number 2 and 10.
I have for OP number 1, man.
Yes. All right.
Supplementary list item number 11.
No taken on record, no instructions dismissed. 11, none appears, dismissed.
Item number 12.
None appears, dismissed.
The opposite one.
Item number 13.
That's true.
Supplementary list item 14.
Item number 14, my lord. There are it's a writ appeal filed by the Odisha Power Transmission Corporation Limited. There I had 2 prayers, my lord. I find that the Lawrence Single Judge order has already been complied with, and this matter was to be heard along with the 10652 of 2015. In the meantime, that 10652 has also been disposed of.
All right. Counsel states that the impugned order has already been implemented. The appeal is accordingly disposed of as having come to choose. It are disposed of matters. No? Please. All right.
My lord, I may be pardoned. Item number 12 may be taken up.
All right. Tell us.
Item 12.
My lord, here I have challenged the order of the single judge. Your Lordship may kindly turn to page 28 of the brief. But this matter relates to selection for the post of Anganwadi worker. But the appellant was initially selected for the post of Anganwadi worker. Got more than 5 years of experience, both as Anganwadi organizer and Anganwadi helper. For a moment, Your Lordship may kindly see the scheme first. Scheme is under Annexure 5 at page 33. Your Lordship may kindly come to page 34. Page 34. My Lord, clause 4 or para 4. Anganwadi helper and organizer, if having the requisite qualification and are found to be suitable, shall be selected as Anganwadi, provided they have worked for more than 5 years. Your Lordship may kindly see the, my Lord, the language employed or used, Anganwadi helper and organizer. My Lord, now Your Lordship may kindly see my experience certificate which I produced before the authorities, that is under Annexure 6. My Lord, Annexure 6 at page 40. The first experience certificate as Anganwadi organizer is from 1/1/2006 to 14/4/2009. Around 3 years. Then Your Lordship may kindly turn to page 42. Here, my Lord, this is relating to Anganwadi helper. My experience is 3/6/2009 to 18/7/2014. Around 5 years. 5 years, more than 5 years. So, my Lord, I have rendered both in the capacity of organizer and helper for more than 5 years. That is the intent or purport of the scheme. And accordingly, I was engaged as Anganwadi worker. Your Lordship may kindly turn Annexure 2 at page 15. I was engaged on 6/12/2014. I joined. I continued to discharge my duties against that post. The opposite party number 5 or the respondent number 5, C preferred an appeal before the ADM, saying that I have less than 5 years of experience, and the learned ADM decided by saying that, well, only in one post, either against the post of organizer or helper, 5 years is to be taken into consideration. And accordingly, my selection and engagement was set aside by the ADM. Against that order, I preferred a writ petition before this honorable court. Now, Your Lordship, may kindly come to the order passed by the honorable single judge. It starts from page 23. My Lord, may kindly come to page 27. The second paragraph. It has been submitted that it is wrong interpretation having been made by the petitioner that the work performed by a candidate as helper and organizer will be taken together. They have submitted that actually the intent of the guideline is that the helper and organizer, since both are different posts, but the holder of these posts are made liable to be considered as Anganwadi worker, provided they have worked for a period of 5 years, and as such experience of 5 years would be taken into consideration of such candidate if performed duty as helper or organizer for a period of 5 years, and the period cannot be calculated, taking the work performed in both as helper and organizer together. But these findings of the learned single judge is contrary to the stipulation made in the guidelines. The guidelines clearly provides organizer and helper. If in the capacity of organizer and helper, one has performed the duties of more than 5 years, then, my Lord, he is to be considered, and accordingly I was selected. That is my first point. Then my second point before your Lordships is, they have taken into consideration my experience as helper, which is also more than 5 years. My Lord, may kindly again see Annexure page 42. Page 42 of the brief. My Lord, this is as Anganwadi helper from 3/6/2009 to 18/7/2014. So it comes to more than 5 years. Since availed leave, my Lord,
4 months almost.
Yes. My Lord, that period was excluded. They say that although I applied for leave, but they say that since leave was not sanctioned, that period will not be taken into consideration because I was not in active service. That is the findings of the ADM and the learned single judge. My submission before your lordships is, my submission, that is 4/6/2009 to 30/09. My lord, so if that period exclusively is taken into account, then also I have completed more than 5 years. And so far as the scheme is concerned, it speaks of both organizer and helper. This is my point.
No, but once you go on leave for 4 months, then that 5-year stipulation is not fulfilled.
So that is one part of the experience. That is the second, experience as helper. But so far as my experience as organizer, that has not been taken into consideration. That is contrary to the scheme. Your lordship may kindly see the scheme again.
No. It's only a combination of organizer and helper.
Yes, organizer and helper. So in the capacity of organizer, I have completed around 3 years, and in the capacity of helper, I have completed more than 5 years. They say that for so far as the helper is concerned, they have excluded the leave period, that is from 4/6/2009 to 30/9/2009.
So that comes to less than 5.
Less than 5, according to them.
So for organizer, you have only 3
years. So both will be taken into account according to me.
That's the only issue. So you want both to be added together.
Yes, that is my point.
Yes, what do you say?
Let me see the guideline.
Revised guidelines.
Yes, madam. Page 34, clause 4.
Yes.
Anganwadi helper and organizer are 2 different posts. So it has been said that who has completed 5 years, he is to be considered. Admitted fact, there is a 3 months gap of 3 months.
No, his only point is you have to add up the 2 things.
Only both can be taken, but the guideline says is not clear in that guideline whether it can be taken into isolated or both. But the 2 different posts are there, Anganwadi helper and organizer. It means if one has completed either 5 years in as Anganwadi helper or organizer, that period is to be taken into account, 5 years.
That is to be read conjointly. But at that end,
that the selected
Anganwadi helper and organizer.
It actually could also mean either of these posts.
Yes, either, not taken together.
I think the rule was not written keeping in mind that the same person could be both helper and organizer.
Yes, that is the confusion.
But then my alternative point before your lordships is, so far as that leave period, exclusion of that leave period is concerned, well, that is also contrary to law. Well, not that I have been disengaged from service.
No, but sanction leave, sir.
No, yes, I have already, my leave application is there.
I know,
together with medical certificate.
If it had been sanctioned, what you say is right. If it's not sanctioned, then you can't include that period. All right. You see, the challenge in the present appeal is to a judgment dated 27 July 2016, passed by the learned single judge, dismissing writ petition civil 12589 of 2016, filed by the present appellant, challenging an order dated 5th July 2016, passed by the additional district magistrate, (ADM), Baleshwar, allowing Anganwadi appeal case number 4 of 2015, filed by respondent number 5, paragraph. The background facts are that an advertisement was issued on 18 July 2014, inviting applications for the post of Anganwadi worker, (AWW), for the Mangarajpur Anganwadi Center, (AWC). Both the appellant and respondent number 5, along with others, applied for the post. Full stop. The appellant was selected. Full stop. Challenging her appointment, respondent number 5 filed appeal case number 4 of 2015, which came to be allowed by the ADM by the order dated 5th July 2016, on the ground that the requisite experience rendered by the appellant either as helper or as organizer, did not satisfy the requirement of 5 years, and therefore her selection was not proper. Paragraph. Agreed by the said order of the ADM, the appellant filed the aforementioned writ petition, which came to be dismissed by the impugned order of the learned single judge. Full stop. The concern of the appellant that the relevant clause in the guideline should be interpreted as permitting a person who has worked altogether for a period of 5 years as organizer or helper to be sufficient compliance with the requirement. Full stop. The learned single judge noted that as a helper, the appellant had served slightly less than 5 years, taking into account a period of around 4 months when she went on leave without sanction. Full stop. As an organizer, she had worked for slightly above 3 years, and this therefore also satisfies the requirement of completion of 5 years, having 5 years of experience. Paragraph. Mr. Swine, learned counsel for the appellant, advanced 2 submissions. Stop. First was that the appellant's experience both as organizer and helper should have to be collectively considered. And if so considered, she would satisfy the requirement of 5 years of experience. Full stop. Secondly, he submitted that the period during which the appellant proceeded on leave as helper should not be deducted from the total years of experience because the engagement is contractual. Paragraph. The court is unable to agree with either of the submissions. Full stop. As far as the first stipulation is concerned, the relevant reads is under. So reproduce from page 34, clause 4. The intention behind the above clause is that 5 years experience should be in the post of either a helper or organizer, since both are distinct and different posts. Full stop. The clause was not obviously inserted, keeping in mind that the same person could serve for some years as helper and for the remaining years as organizer. Full stop. The interpretation placed by the ADM on the said clause cannot be said to be erroneous. Full stop. It has been rightly affirmed by the learned single judge. Paragraph. As far as the second issue is concerned, admittedly, the appellant proceeded leave for about 4 months without the leave being sanctioned. Full stop. The mere submission of a leave application would not regularize such leave. Full stop. Since the appellant does not satisfy the requirement of 5 years of experience as organizer, as helper, sorry. If the leave period is deducted, no fault can be found in the order of the ADM. Cancelling her appointment as AWW. Paragraph. The court is unable to find any error having been committed either by the ADM or by the learned single judge, which calls for interference. The writ appeal is accordingly dismissed.
Supplementary list item 15.
None
Item
appears
number
dismissed.
Item number 16.
In this case, the benefit of financial benefit has been denied to petitioner, who is a candidate of a student of a BTech engineer. And the case is like this, my lord. Under Annex 2, the the petitioner was a candidate of BTech engineering, and there is reserve category of OJE 2013. So under the reserve category, that is a reserve of TFW, that is tuition fees over scheme. Let's see, page 22, that is eligible criteria for OJE 13 for tuition fees over scheme, that is called TFW scheme. So in order to claim that category, the student must be the candidate parents' income, all sources should be lesser than 4.50 lakhs yearly. To claim seats under TFWC, this candidate will have the submitted income certificate as per eligibility criteria OJE 2013 and the time of document verification. The scheme will involve only tuition fee, and all other fees except tuition fee will have to be paid by the candidate. To be eligible for TFW scheme, the candidate should be a native candidate of Odisha as per eligibility criteria. TFW scheme is applicable to all the AICTE approved institutions. According to eligibility 2013, the candidate will have to submit the following documents at the nodal center during document verification, that is native Odisha and parents' income. So far as my lord, the last part of that page, 1, 2, 3, 4 point, my lord. There will be last from the bottom, my lord. There will be some seat which will come under the tuition fees over scheme as per Odisha J 13. Reservation of seats, around 5% of seats will fall under this category. So only 5% seat will be allotted under the TFW, 5% that is category. Then, my lord, the next page is 23. So here is also eligibility criteria for TFW, and same thing has been that is in para 3 that has been mentioned. The waiver is limited to the tuition fees as approved by the government of Odisha fee committee for self-financing institutions and by the government for the government institutions. All other fees except tuition fee will have to be paid by the beneficiary.
So why can't he get, the person who got the tuition fee waiver did not join?
Yes, madam.
So why can't he get it? He's next in line.
He should.
Such a straightforward case.
Yes, madam.
You have finished your course now?
I finished
by paying the fees.
On protest, my lord, last order, my lord, in this honorable court.
How much does it work out to?
Well, according to the fees, 67,000 per year.
Oh, for 5 years?
4 years.
4 years. So 3 lakhs.
2.30 lakhs.
You should get it, sir.
So last order, lordship, kindly see, I have paid the balance amount, that is the lordship on protest directed to deposit.
All right.
That is order, my lord, dated 21/7/2017 in the writ appeal.
All right. Agreed by the denial of tuition fee waiver.
I am appearing for the OP number 3 and 4.
Anyway, it's a government institution.
No.
Is it a private institution or government?
It is a university.
No. But tuition fee waiver means the government will pay.
Government will pay.
If he is entitled, Miller, there is no difficulty, Miller. Your Lordship, kindly see, it is guided by the Orissa Professional Educational Institution Regulation, Admission and Fixation of Fee. Section 3, Miller, provides.
Where are you reading, sir?
Miller, your Lordship, kindly see the counter filed by the
in the writ petition.
Respond number 1 and 2, they have filed counter in this writ appeal also. They have also filed counter.
No counter has been filed writ appeal.
Writ appeal, there's no counter, but anyway, let's look at the writ petition.
Writ petition, Miller. Your Lordship, kindly see 2 on the direction of the honorable court. They have filed 2 counters, one preliminary counter, one additional counter. Your Lordship will get it.
890.
Mr. Palit was appearing for the JE.
827.
Your Lordship, That is counter filed on 5/5/2015.
In REIT application, counter has been filed.
Oh, this clause 3 is set out.
Para 6.
Section 3, subject to the provisions of this act.
Para 6. Para
Yes.
4 and 6.
Correct.
That the section 3 of the said act, aforesaid act prescribes following provisions regards to the admission of professional technical colleges. Section 3, method of admission in professional educational college. Subject to the provision of this act, admission students, private educational institution, government institution, and sponsored institution, including the entry seats, shall be made through JEE conducted by the policy planning body by centralized counseling in order of merit. In accordance with such procedure, recommendation recommended by the said body, approved by the government. This is Millard. The institution has nothing to do. The committee will recommend on the basis of the rank, and each rank is 12,377. And the person who has allotted the seat is 8,777. Is below 3,330 position, Millard. So if any seat is available, that will go to the next meritorious candidate, not to him. That is the counter, Millard. Para
No, but the next meritorious candidate did not apply. The whole case is about tuition fee waiver, sir.
Tuition fee, that is also mentioned, Millard. Tuition fee waiver, if a candidate, if he is now taken admission in general category, he has completed the study in general category. Now he says, Millard, he has come to this honorable court saying that the candidate who was allowed the tuition fee waiver rank, that is 8,000, Millard, the rank is
800,777.
8,777. Each rank is 12,000 something. That he has mentioned, Millard. Your Lordship kindly see page 10 and 11 and 12. That is clearly mentioned. Is even that seat is allotted to a candidate, he has taken admission. Thereafter, he left the college. That will not go automatic to the other person.
It's not about that seat, sir. I think you're missing the point. It's only about the tuition fee waiver. He finished his course. He's not claiming any seat, nothing. He's only talking of tuition fee waiver.
Tuition fee waiver is not entitled. That is the counter, and your Lordship.
See, mere saying it is not does not mean he's not entitled. You have to tell us why.
Yes, that is the reason we are giving. Your Lordship kindly see para 10 of that counter.
We have it.
That the claim and comparison of the petitioner with another candidate with the rank, the holder of 8,777.
So this is a complete misunderstanding of what the point is.
Point is, Millard, the tuition fees waiver seat was allotted to this candidate, 8,777. That candidate is Millard admitted. Thereafter, he left. Now his case is he was given. He was ranked 12,107.
Sir, there were no other claimants for the tuition fee waiver.
Yes.
There were only two claimants.
Two claimants.
One got it.
No. If two claimants, Millard is entitled. It is not two claimants.
Where have you said there are other claimants for tuition fee waiver?
Yes, your Lordship kindly, para 11. If a candidate is left who has taken admission, that the next person is not entitled. That is para 11.
Unless there are other claimants, sir. Where is your statement that there are other claimants for tuition fee waiver? Where is your statement?
But the submission of the petitioner that as the candidate with rank 877 left the college is eligible to get the benefit of TW scheme is baseless and illogical. Once the candidate allotted a seat as per his rank, then there is no scope to re-allot student another seat. If this is considered, then there will be a rank violation and against the principle. The judgment I am placing para 4, your Lordship kindly see the para 4.
Strange, very strange.
judgment, Millard, they have elaborated 5 discuss para 1 to 3. This argument was made and that was considered, and in para 4 it is held, Millard, that on going to the procedure as per the guidelines for the selection of candidates is entitled to benefit of the TRF scheme, for which some seats of colleges of the state are reserved. It cannot be said that the other candidate who has allotted the seat in the college under TRW scheme would have declined to take the admission. Petitioner would have selected the next candidate and to get the benefit under that scheme in the counseling. Thus, it is not permissible to say that the benefit of the scheme is to relate to this petitioner in view of the absence of the so selected taker of the same, that is other selected candidate as per the ranking. As it not there, the petitioner was the next waiting for the same so as to conclude that the benefit of the under the circumstances, if known to them, would not have gone to any other candidate who had also so opted with better ranking than the petitioner, then there would not have been any other taker of that. So merely because other candidate who had been allotted with the seat under the TRW scheme did not take admission to the said college, the foregone claim of petitioner as per the earlier option does not mature afresh so as to claim this entitlement and benefit under some scheme. So it is also violates the what they say, the JE authority under the act, a committee was there and committee after that allotted the seat. He has taken that allotment and joined as a general candidate. So, Miller, if this is allowed, a person who is below 3,300 rank, if other candidates would have, is not given, he would have given to them. That, Miller, the counter filed by JE, that counsel, Miller, your lordship kindly see, a preliminary counter copy was given to me in the writ appeal. That is also taken stamps, and this is the, your lordship, he is appearing for the institution.
I'm sorry, Manoj, I have filed the same counter. Manoj, our stand is we have already made the allotment as per rank.
That's not even the issue, sir.
Manoj.
He's not saying his rank should have been higher. He's completed his course also.
Yes.
The issue is only about tuition fee waiver. It's not about seat at all.
No.
So what's your, in fact, we have failed to understand what is the issue with the university or the JE.
In fact,
only the government is going to pay the fees. And the tuition fee waiver means it's only the government.
It's the government who's to.
That's all he wants. He's not bothered about.
We are not no way concerned.
That's
way we
all.
are not.
In fact, I tried telling, he's refusing to understand, but that's okay.
Even accepting.
For this issue, the main contesting party is the government.
Is the government.
The government has no problem.
Rightly, Manoj.
Correct.
Even accepting, allotting him a rank.
That's all. You have no other role.
The college
he's not contesting it. He doesn't say I should have got some higher rank or anything. That's not even his case.
So is the government
correct? And they are not. See, they have not opposed his plea now. So anyway, the challenge in the present writ appeal is to an order dated 5th January 2017 passed by the learned single judge dismissing the appellant's writ petition civil 10294 of 2014. Paragraph. The appellant, who was successfully selected for the 5-year course in biotechnology at the GIET Gunupur in Rayagada, bracket, a government institution, bracket, had applied for tuition fee waiver bracket TFW under the TFW scheme. Full stop. The appellant had sat for the Orissa Joint Entrance Exam bracket OJEE bracket 2013 and got admission in the biotechnology discipline mentioned institution through counseling. Full stop. He was admitted in the general category as per the rank obtained by him, which is 12107. Paragraph. Another student who also secured admission in the GIAT Gurupur through the OJEE secured a higher rank of 8,777 and was allotted a seat under the TFW scheme. As it transpired, the said candidate who had secured the 8,777 rank
there is one more difficulty here. I'm sorry, Lordship, may permit me. I'm not this. There's one more difficulty. Since his rank was lower, he was given an allotment under the general category.
Maybe. No.
So that there.
I have already mentioned this general category.
Right.
Who secured 8,777 was allotted a seat under the TFW scheme. However, as it transpired, the said candidate did not pursue the course and accordingly, the only other candidate who had laid a claim to the TFW was the present appellant. Full stop. His argument before the learned single judge was precisely this. Full stop. Once the candidate who got the TFW did not opt to continue the course and left the course, the other person who claimed TFW should be granted the TFW. Paragraph. The learned single judge has in the impugned judgment negative this plea, observing that merely because the successful candidate who got the TFW declined to take the admission would not automatically mean the next person with a lower rank would get the TFW. Paragraph. It was nobody's case that, and particularly not the state's, that there was any other competing candidate with a higher rank than the appellant who was seeking the TFW. Full stop. From the facts brought on record, it appears that the allocation of a TFW seat is as per merit. Full stop. Since the other candidate with the rank of 8,777 was of a higher merit, that candidate got the TFW. Full stop. However, with the candidate who got the TFW declining to take the admission, there was absolutely no one else who had claimed TFW other than the present appellant who remained as a claimant for the TFW. Full stop. There should have been therefore no difficulty whatsoever in accepting the plea of the appellant and granting him the TFW. Paragraph. During the pendency of the writ petition and the present appeal, the appellant has already completed their course. Full stop. It is not in dispute that he had paid the fees under protest. Full stop. Paragraph. This court has heard the submissions of learned counsel for the appellant, for the state, for the JEE and the institution in question. Full stop. The court has no satisfactory explanation offered by counsel of the state why the claim of the appellant for TFW ought to be rejected even after the person who was granted the TFW failed to join the course in question. This court is unable to agree with the conclusion reached by the learned single judge that once the person allotted the TFW failed to join the seat, the appellant, who was the only other candidate who was a claimant for the TFW, cannot automatically be granted it. Full stop. On the other hand, this court finds that there is no bar in the facts and circumstances of the case to the appellant getting the benefit of TFW. For the aforementioned reasons, this court sets aside the impugned order of the learned single judge, allows the appeal, and directs that the appellant would be entitled to the TFW for the entire course, which he successfully completed. The tuition fees paid by the appellant will be now refunded to him by the state.
Here, you lost the state. The allotment was made general candidate. We have admitted him in the general candidate. He completed a general candidate. With the TFW benefit is entitled. Now, how the institution will be at Millard? We have admitted him. Your last Annex 3. We have given general seat.
It's not state to refund, not the state.
State to refund.
State will refund and state will realize because the institution has taken tuition fees. So that's why, my lord, where the TFW candidate, the person will not pay the tuition fees. And that will be borne by the government. And government will pay the institution.
Yes, anyway, so it's all from one pocket to the other. As far as you're concerned, the government will give you the refund.
Government will give.
Within a period of 4 weeks from today, failing which the amount will be paid together with simple interest at 6% for the period of
That's some more time.
All right, 8 weeks, failing which. All right. The appeal is allowed in the above terms. No costs.
Supplementary list item number 17.
And please, your lordship. And in this case, the appellant has challenged the order of the honorable single judge, my lord, dated 16/5/2017 under Annexure 3, my lord, by which, my lord, during the penance of the suit, my lord, this honorable single judge, my lord, entertained the writ petition and directed to the opposite party number 1 and 2, my lord, to restore the water connection to the premise of the opposite party, respondent number 1, my lord. And taking advantage of that order of the honorable single judge, my lord, the opposite party number, respondent number 1, with the help of a private plumbers, my lord, the blockage the ground floor of the water connection, and also creating advances there, my lord. Though the appellant is the Shiksha Vikas Samiti, my lord, and who having right title interest over the disputed land.
So how is this writ appeal maintainable, sir?
Maintainable because, my lord, that is honorable single judge, my lord, lordship, you can have a glance the order, my lord, passed on 16/5/2017, my lord. Background of this case, my lord, the petitioner is the Shiksha Vikas Samiti, my lord, who sells the land from the original owner by virtue of a registered sale deed, my lord. And lordship, Annexure 1, that is the registered sale deed.
Sir, did you follow the question I asked you, sir?
My
what is the question, sir?
The maintainability with regard to the writ appeal.
So what is your answer to that, sir?
Since there is a wrong, my lord, in the order of the honorable single judge.
Everything that is wrong,
the
writ appeal is maintainable?
Maintainable. That
what is the meaning of maintainability?
Within the period of that is limitation.
Maintainability, sir. Maintainability is different from limitation. What was the jurisdiction exercised by the single judge?
Honorable single judge, my lord, though the suit is pending, my lord.
So arising from a suit, an interim direction, a suit, a writ petition was filed.
No, my lord, not interim direction in the suit, my lord. Not interim direction, but only, my lord, on the writ petition made by the respondent number 1, my lord,
for the blockage of a water connection.
What was prayed in the suit, sir?
Prayed
Come to the
suit
prayers in the prayer in the writ petition. Let's come to the prayer in the writ petition.
Bless you, my lord. For restoration of a water connection to the premise of the petitioner that has been prayed in the writ petition. But you can have a glance of prayer. The petition therefore prays before your lordship may graciously please enough to allow this writ petition and may kindly issue writ of mandamus direction to the opposite pattern number 1 and 2 to connect the PhD water supply under BMC area to the house of the petitioner in the first floor over plot number 101/957 of Mauja, Komikhal, Rasulgad, Bhubaneswar, and further may be pleased issue writ of mandamus directing the opposite party number 3 to take immediate and appropriate legal action against the opposite party number 4 on his tap and workman. And this was the prayer, my lord. The order of the interim order of the learned, my lord, civil court has not been challenged. During the pendency of the civil suit, my lord, the petitioner filed a petition, my lord, seeking direction for water supply, my lord, to the first floor of the plot number 101 of 957.
Who's the other side, sir, here? Who's appearing for the other side?
May I be pardoned to Lordship? I am on virtual mode. Lordship, I am feeling feverish. That's why I am not able to present before your Lordship. I am appearing on behalf of Mr. S.S. Das.
Yes, where is Mr. Das?
Lordship, he is out of town.
All right. Counsel appearing for the contesting respondents. Some personal difficulty today. List on 6th February.
Supplementary list item 18.
Oblige, your Lordship.
None appears dismissed.
For the opposite person.
All right.
Item number 19.
May I please read, my lord, on behalf of Mr. A. Das, my lord, I pray for commencement taken of next week, my lord, because his mother was not well.
All right. Counsel, the appellant state in some personal difficulty. That's all. 13th February.
Oblige.
Item number 20.
These are lordships. But in this case, the issue regarding taxability of the vehicles which are used in the mining area was decided by the Honorable Single Judge. There are two contradictory decisions of the Honorable Apex Court, relying on the one where the taxable provision is there, where it said that it has to be taxed, that has been relied upon. In the central government has already issued a notification exempting all these category of vehicles from the applicability of the tax. So unfortunately, I couldn't file the affidavit. Okay, copy it. So, notification. I'll just lots. I'll file it by way of an affidavit so that the
All right. Mr. Nandal and the senior counsel for the appellant states that there has been a subsequent notification issued by the central government exempting the vehicles, PSUs.
No, my lord, HEMM, that is heavy earth moving machines which are used in mining operations.
Yeah, heavy earth moving machines used in mining operations
from within the mining area only.
Yeah, from motor vehicle, within the mining area from motor vehicle tax. He states that he'll place the notification with an affidavit before the next date. Add his request list on 12th December. We'll have 14th December. Interim order to continue.
Item number 21.
None appears dismissed.
Item number 22.
May it please Allah. My lords, this writ appeal is directed against the judgment of the learned single judge at Annexure 1.
Yes.
My lords, the factual backdrop of this case are like this. State government in its industry department for boosting the industries, time to time announces package of incentives. And in that industry category, hotel is also one of the industry. The petitioner before Lordship, the appellant before Lordship, being attracted with the 92 IPR, packages declared under the 92 IPR, purchased a hotel sold in an auction by under Section 29 of the OSFC State Financial Corporation Act. My lords, so far as the IPR is concerned, my lords, the IPR 92 also says that the hotels, the units purchased during the because of the by virtue of the auction sale will also be entitled to get the incentive. May I take your lordships to 17.1? I have also quoted it in my writ petition. 17.1 of the.
It's there in the judgment, sir, page 23.
Beg your pardon?
Page 23.
Yes.
It is set out.
Yes, yes. Judgment is set out. My lords.
New hotels, motels, wayside amenities.
Now, my lords, and what has been used against me is clause 14. It has been 14.2. Any industrial unit seized under Section 29 of the State Financial Corporation Act and thereafter sold to a new entrepreneur shall be treated as new industrial unit for the purpose of sales tax and octroi concessions only.
Not electricity tariff.
Now, my lords, transport value of the unit, this has been used against me.
No, because the last line also,
yes,
because this is not silent about electricity. It says arrears of electricity.
Yes, silent. Now, my lords, I filed a writ petition. The industries department as well as the distributing company, they filed their counter affidavit. Now, the stand of the industry department, that is Annexure 5, lords will see page 40. There, my lords, the industry department says, okay, it is with the state secretary, industry department, we have got nothing to say about that. That lords will find page 41, paragraph 4. Then they come to say, para 8, they say that for never disputes the said industrial policy pronounced by the government from time to time for ensured benefit to the different entrepreneur as well as the hotel units. Now, the distributing company, they say that we are not going to be compensated under Section 65, where the compensation has been provided to the distributing company. Since we are not going to be compensated, so we will not extend that benefit. This is the stand of the state government. And they say that this is only for commercial. This is complete departure from the package of incentives declared by the state government, that the cabinet decision. Now, my lords, and second stand they have taken that there has been no regulation or suitable direction from the state government to the distributing company or the industry department to give this benefit. Now, my lords, may I turn to one judgment only I will cite. That is Manuel Sons Hotels Private Limited, where the Honorable Supreme Court said that the policy, the promissory estoppel its foundation is on equity, and it should not be read as a rigid one, and it should be in a flexible one. That is your lordship will kindly.
Here that question doesn't arise because
No, that question I'll just say, and ultimately the Honorable Supreme Court directed that doctrine of promissory estoppel. Lordship may allow me.
No, here there is no promissory estoppel. See, here you got it under an auction.
Yes.
Section 29 SFC Act.
Correct.
For your category of industry,
yes,
there is a specific clause 14.2.
Yes.
Unless you overcome 14.2, the question of promissory estoppel does not arise.
My lords, may I say one thing? Lordship will kindly see.
Yes.
Those hotels which have started making investment and have come after the effective date, that is 1st of August 92.
When did the auction take place?
My lords, what I gather from my information, I've stated, and the counter also states by the distributing company that 15/8/92. 15/8/92, my lords. That is the thing.
So there seems to be a deliberate, conscious decision taken to exclude units that were purchased under Section 29.
My lords, if that interpretation will be taken, then the units which have been purchased by the State Financial Corporation, although is a new industry, new hotel, will be deprived of the benefit.
It's still like a first user and second user. The entrepreneur who invested and built that hotel, whatever it was, he is the intended beneficiary under this whole scheme, IPR 92, not the sub. That seems to be the logic.
That has not been stated.
It's like the new car and used car. It's like that.
That is correct. But the entire logic behind is to boost the hotel industry, my lords. That is the thing. And second thing, my lords, error is the learned single judge completely misconceived himself by saying that it is a commercial category. How it is a commercial category? That is the thing, my lords.
Why not? Why is it a commercial category?
My lords, it is an industry, and I have been given the certificate by the GMDIC as an industry. That is, Lordship will see Annexure 2 at page 27.
Yes.
Then because of the fact that no regulation or no instruction have been issued to extend the benefit of the energy charges to be charged at the industrial rate, I will be deprived of that, my lords. And that is why I was bringing to your lordship's kind notice of the judgment of this of the Honorable Supreme Court. Lordship will kindly see para 39 of the judgment. In the present case, it is clear that no writ of mandamus is being issued to the executive to frame a body of rules or regulations which would be subordinate legislation in the nature of primary legislation, bracketed, being general rules of conduct which would apply to those bound by them. On the facts of the present case, a discretionary power has to be exercised on facts under Section 3A of the Kerala Building Sale Tax Act 1975. The non-exercise of such discretionary power is clearly vitiated on account of the application of the doctrine of promissory estoppel in terms of the court's judgment in Motilal Padampat and Nestle Supra. This is for the reason that non-exercise of such power is itself is arbitrary act which is vitiated by non-application of mind to relevant facts, namely the fact that a government order dated 1886 specifically provided for exemption from building tax if hotels were to be set up in the state of Kerala pursuant to the representation made in the GO. True, no mandamus. Yes. Here, my lords, the stand of the distributing company, I'll take your lordship only to the stand of the opposite parties, that is the once, lordship will kindly pardon me to that para, page 48, the writ appeal, internal page 4, where prevented them to not to charge industrial policy tariff is this. On such restructuring, 4 numbers of distribution companies were created, including the Nesco Limited. The said company is being managed by a private company, and the government has refused to extend any subsidy to this company for the loss sustained due to extension of IPR benefits. That is the reason, my lords, for which I have been deprived of. Nothing else. The entire foundation is on equity, my lords. And second thing they have said, the hotel in question is a business establishment. True, but it is the intention of the state legislation, my lords, to boost the hotel, the tourism industry. And that is the reason from 1986, they are declaring this package of incentives for the growth of the tourism industry. This is the main object. How can one because you will be not given compensation. Therefore, you will not extend.
Who's for the other side?
State.
As I appear for the Industries Department, NESCO there'll be someone else.
Who's appearing for that NESCO?
NESCO.
I think
is TP and
TP and after
they have a separate
taken
plan.
over, I'll make them parties. TPCODL.
All right. You say counsel for the appellant seeks leave to implead the Tata Power Distribution Orissa Company Limited in place of respondent before. The steps be taken within the next 2 weeks. It's on 4th January. All right.
Mellors are posting it to
4th January.
4th January.
Supplemental list item 23.
The memo is taken on record. Appeal is dismissed as not pressed.
Item number 24.
None appears dismissed.
Item number 25.
On behalf of Mr. Bahari, no instruction, my lord.
No instructions dismissed.
Item number 26.
Let's meet please, your lordships, my lords. In this case, my lords, notices were issued. Now, in the meantime, counter and rejoinder, everything has been filed. But if your lordship sees the notice, the AD is not back from respondent number 8, my lords, who is the contesting respondent, and her appointment is under challenge. I am ready with the matter, my lords, or if your lordships direct, then I can take fresh notice on her.
Notice to respond by 8. The AD card has not been received back from respond by 8. Fresh notice returnable. 9th February. The tracking report be placed in record.
Item number 27.
Wait, please. Item 27. The impugn order is at Annexure 18, page 74. In this case, my lord, this is a matter concerning appointment concerning Shiksha Sahayak under Sarva Shiksha Abhijan. The appellant is already appointee as a teacher Shiksha Sahayak. His only grievance was that his appointment may be predated because his appointment was made later by intervention of this honorable court and the later selection committee, the collector. Therefore, the initial appointment of all other similarly placed candidates were in 2007, but due to some latches by the government, the appointment was finally regularized in 2009. So therefore, the only prayer is that his appointment may be predated from 2007.
When did you come to the court?
I have come to court. This is the 4th instance I have come to the court. The first instance was...
When were you finally appointed? What date were you appointed?
I was appointed in the year 2009.
No. Then where's the question of coming in 2015?
Yeah, before that, at least 3 writ petitions were filed. For that, if your lordship allows me, I will place small facts are there. There are 4 or 5 only annexes which will suffice. I will answer to your lordship questions. Why in 2015 I have appeared to the writ petition. Earlier, the writ petitions have been filed. The first was after I got my name was not in the merit list. In the 2007, I made a representation before the collector, and when it was not interfered, this honorable court interfered in the matter, and direction was given to the collector to consider his case. That was the first writ petition. Thereafter, the collector.
Give us dates, sir.
Yes, my lord. The first.
Paragraph 4 of the counter you have stated.
The first writ petition was in the year 2008, 4245. I have submitted a date chart that is also there on record, page 68. There, all the date chart is there, all the events are there. The first writ petition was filed in 2008. There was a direction given to the collector to consider my representation. And accordingly, the collector decided, that is Annexure 8, page 34, that my appointment is to be made. That is in the year 2009. My lord, only may peruse page 34. That is this in genesis of my case. Page 34, it was finally said at para 11. Similarly, from final panel list of SCBC category, the name of to be deleted, and in such place the name of petitioner Sri Bharat Chandra Naik, that is me, be inserted, after which resultant benefit to be extended to the petitioner. This was the order, my lord, and this order was not complied with. Again, I filed a writ petition. That was in the writ petition of 2009, my lord. That writ petition, again, page 40, my lord. There is a very categorical finding, page 40 of the writ petition. Page 40, your lordship, it is said, the direction was that it is unfortunate case where despite the order of this court and consequential order of the collector, the district project committee is reluctant to implement it. The collector Baleshwar is hereby directed to ensure that his order dated 26/3/2009 in pursuance of the order of this court is implemented within 7 days from the date of the production of the certified copy of the order. If the order of this court is not implemented within the aforesaid period, the collector Baleshwar will be held personally responsible for the same. After receiving this order within 7 days, I was there. That appointment was page 11, that is in the year 2009, my lord. Now, my lord, after this appointment I received, I made a representation that because this was not my fault of getting delayed appointment, my appointment may be related back to antedated.
So when did you make that representation?
My representation,
You prepare a list of dates.
That list of
you
dates.
Just prepare a list of dates and argue. I think that will be better. Otherwise, you'll be stopping at every point. You say counsel for the appellant will prepare a proper list of dates before the next date with an advance copy to counsel for the state. List on 12th January.
Item number 28.
28, your lordship, brief has been transferred from me.
All right. Mr. Mahapatra states the brief has been transferred from him.
Opposite party number 5.
All right. None appears for the appellant. Dismissed for non-prosecution.
Item number 29.
Lord, 29, 30 and 31, similar matter, it may a week's time because the brief has come to me today morning only.
At the request of Mr. Nanda, senior counsel for the appellants. It's on 15th February.
Item number 32.
Date in
15th February.
Lordship, my appearance on behalf of ITCO, may be please note.
Item 32.
None appears dismissed.
Item number 33.
In item 33, AD is not back from respondent number 5 when contesting opposite party.
All right. You say fresh notice to respond to 5. 19 January.
Item 34.
Wait, please, your lordship. Your lordship, this is a matter where I'll take your lordship to section 7B of the Employees Provident Funds and Miscellaneous Provisions Act. I have quoted at page 11. Your lordship may kindly have a look. Page 11 of the writ appeal, your lordship. Your lordship gets it, 7B.
You are appearing for the B of Commissioner. All right.
Your lordship, may I place your lordship?
Yes, please.
Yes. Any person aggrieved by an order made under subsection 1 of section 7A, but from which no appeal has been preferred under this act, and who from the discovery of new and important matter or evidence, which after the exercise of due diligence was not within his knowledge, or could not be produced by him at the time when the order was made, or on account of some mistake or error apparent on the face of the record, or for any other sufficient reason, desires to obtain a review of such order, may apply for a review of that order to the officer who passed the order, provided or that such officer may also on his own motion review his order if he is satisfied that it is necessary so to do on any such ground. Every application for reviews under subsection filed in such form and manner is within such time as may be specified in this scheme. The prevalent rule is that 79 para 79A, how the application of review shall be filed, Your Lordship. Then Your Lordship 3, where it appears to the officer receiving an application for review that there is no sufficient ground for a review, he shall reject the application. 4, where the officer is of the opinion that the application for review should be granted, he shall grant the same, provided that no such application shall be granted without previous notice to all the parties before him to enable them to appear and be heard in support of the order the note of which a review is applied for, and no such application shall be granted on the ground of discovery of new matter or evidence within which the applicant alleges was not within his knowledge or could not be produced by him when the order was made without proof of such allegation. Now, Your Lordship, important is 5. No appeal shall lie against the order of the officer rejecting an application for review, that is under subsection 3. But an appeal under this act shall lie against an order passed under review, that is section 4, as if the order passed under review were the original order passed by him under section 7A. Then, Your Lordship, I have also referred to that 7I, which relates to appeals. Any person aggrieved by a notification issued by the central government or an order passed by the central government or any authority under the proviso to subsection 3 or subsection 4 of section 1 or section 3 or subsection 1 of section 7A or section 7B, except an order rejecting an application for review referred to in subsection 5 thereof, or section 7C or 14B, may prefer an appeal to a tribunal against such notification or order. Your Lordship, here what has happened, my 7A application, 7A order was passed on 30/12/2005, Your Lordship. And thereafter I filed a review on 12/5/2006, Your Lordship. That while the review was pending, Your Lordship, on 10/8/2000, manner that 6/9/2006, Your Lordship, which is Annexure 4 to the writ petition, Your Lordship, the review application was rejected, Your Lordship. Then that 6/9/2006 order, rejection order, I challenged in WPC number 13457 of 2006, Your Lordship, because no appeal was maintainable.
Right.
My Lord, Your Lordship is saying something.
So what is the writ petition? What has happened in the writ petition?
Yes, page 32, Your Lordship.
Yes.
Order which is attached, Your Lordship, impugned order.
Yes.
Hard Sri Incommissional and Senior Counsel for the petitioner and Sri S.K. Patnaik for the opposite part number 2.
Oh, only because you have a scope for filing an appeal.
No.
No. The learned single judge
Yes, he said that the order merges, Your Lordship. That is why I am before Your Lordship. This is against the statute.
Obviously wrong.
Yes.
It's a clear exclusion, sir.
Yes.
Well, there is an appellate remedy against 7A order. 7A order itself is appellable.
That may be. Against review, there is no appeal, sir.
Yes.
Because the statute excludes the appeal.
Correct.
No, I am not saying that. 7 order is appellable. 7 order is appellable. Instead of filing appeal, he chooses a form of 7B on which are not grounds are not available. On new facts are not available. That is the 7B order. There are no new grounds. The 7B
But the fact remains, sir, against that order. In fact, it's the other way around, isn't it? That order merges with the subsequent order in review. That's how it should be.
Well,
now it becomes an order in review. It is not appealable.
7 order is still appellable.
7A is appealable, not 7B.
Yes.
Maybe. 7 order is still appellable. Only single judge go on.
There is no, that 7A order is now merged with the review order.
Not that. Had it been modified?
It's the merger is this way around, sir.
Man.
You can merge with something subsequent.
So what? He doesn't want to file appeal then?
Obviously, that's why he filed a writ petition.
No, my lord. Then, my lord, in every case, suppose 7 order
not in every case.
I'm just submitting, my lord. 7 order is passed. There is no ground for
Party may
review.
choose. So there are two options always. Even now it happens. Single judge passes an order. If you feel no error apparent to the face of the record, you file a review. If you feel
Not
no,
that it is rejected.
it's done on the available record, then you file an appeal.
Yes.
The choice is the party.
Yes, madam. Now
Once the
the
party
question
chooses
is-
a review, then that route has to be followed.
If the review is rejected on the ground not maintainable, on section 3.
No, these are statutory. See, if the
Yes, I don't
statute
dispute
had not specifically excluded the provision of an appeal against an order in review, what you say is right. In the normal course, it is right.
Yeah.
But where a statute specifically excludes,
I don't dispute that. I accept that. Now the question is, if somebody is 7 order, then files a review, there is no ground as per Procedure 7B, is order 43 rule 1 CPC.
that's a chance that
then
the
will
party
file-
takes.
in that
See, that's
case-
the chance that the party takes.
Well, then, in that case, everybody file a review petition 7B without being maintainable,
May
then
not.
come to this honorable court.
This is what I'm saying. We don't have to presume that because of this one order, everybody will start filing only review. Not
So,
like that.
If there is no ground of review, you file a review rejected, then it is not maintainable.
We just have to interpret the section, sir, not what party might or might not do. We have to interpret the provision.
Our own high court decisions are there. 7 is maintainable. If he can still file.
7A is maintainable. We are now not 7A. We are on the review.
Review is not applicable. Let us say it is not applicable. But he has still file appeal against 7B order. 7 order. Having this review not maintainable, he can still file appeal against 7 order. That my single judge has said you go to appeal.
No. He has said it's a merger and therefore
That may not be correct. That may not be. I don't subscribe to that view. But still then he can file appeal.
Yeah.
Having used the time in 7B unsuccessfully, he can still file appeal.
All right. You see, the challenge of the present petition. The present appeal is to an order dated 13th December 2017 passed by the learned single judge, rejecting the appellant's writ petition civil 13457 of 2006 on the ground that the appellant had an efficacious remedy of the statutory appeal under section 7 capital A of the EPF and MP Act 1952 paragraph. The background facts are that the appellant which is admittedly covered under the Act, was issued a notice dated 17 January 2005 under Section 7 capital A of the Act by the Regional Provident Fund Commissioner, bracket S number 2, on the ground that there was a significant drop in monthly membership and remittances over months. Full stop.
May I just intervene if you don't?
Following the
Yeah, that is Assistant Provident Fund Commissioner.
or Assistant Provident Fund Commissioner. All right. Following the said notice, an order was passed by Respondent 2 on 30th December 2005, holding the appellant liable to make contribution to the tune of rupees 109 for the period from June 2004 to November 2004. Paragraph. Agreed by the above order, which was passed under Section 7 capital A of the Act, the appellant filed an application for review under Section 7 capital B bracket 1 of the Act. Full stop. Even before the review could be taken up for decision, a summons was received from the recovery officer full stop. The recovery officer also passed an order on 11th August 2006 proposing to take coercive action if the appellant failed to make payment of the demanded sum. Full stop. In the circumstances, the appellant filed writ petition civil 11076 of 2006, in which notice was issued and interim protection was granted. Paragraph. During the pendency of the said writ petition, view petition filed by the appellant was taken up for hearing. Full stop. On 6 September 2006, the said review petition was rejected on the ground that it did not raise any fresh issues apart from the one which had already been taken into account when the order was passed in the section 7 capital A proceedings. Paragraph. Agreed by the rejection of its review petition, the appellant filed writ petition civil 13457 of 2006. Since the appellant was of the view that under section 7 capital I, read with section 7 capital B bracket 5 the Act, no appeal was maintainable against an order rejecting a review petition under section 7 capital B of the Act. Paragraph. The learned single judge, by the impugn order dated 13th December 2017, has dismissed writ petition civil 13457 of 2006 on the ground that, in terms of the doctrine of merger, the order in review under section 7 capital B of the PF Act merged with the earlier order under section 7 capital A of the Act, which in any event was appealable. Full stop. Paragraph. Third, the submissions of Mr. N.K. Mishra, learned senior counsel for the appellant, and Mr. Mohanty, learned senior counsel appearing for the
S.K. Patnaik.
Oh, sorry, Mr. Patnaik, learned counsel appearing for the learned senior counsel appearing for the respondent. Section 7 capital B of the Act reads as under, take from page 11. 7 capital B and 7 capital I of the Act read as under. Further section, the para 79 capital A of the EPF scheme provides as under, take from page 14. Paragraph. It is plain that there are two options available to a petitioner, a party that is aggrieved by an order passed under section 7 capital A of the Act. One is to file an appeal as provided under section 7 capital I of the Act. The other is to file a review under section 7 capital B of the Act. If the latter course is chosen, then no further appeal lies against an order review. This is plain from a reading of section 7 capital I bracket 1 of the Act, which in parenthesis expressly excludes an order rejecting an application for review from the purview of section 7 bracket capital I bracket 1 of the Act. Would there be a clear statutory bar to the maintaining of an appeal against an order rejecting a review petition? The appellant could not have been relegated to that remedy. Full stop. Such an appeal was clearly not. Full stop. Paragraph. The doctrine of merger would only, in the facts and circumstances of the present case, given the express bar under section 7 capital I bracket 1 of the Act, the doctrine of merger would only mean that the order under section 7 capital A of the Act has merged with the order under section 7 capital B of the Act. And therefore, what remains is only the order under section 7 capital B of the Act, against which no appeal is maintainable. Full stop. For the aforementioned reasons, the impugn order of the learned single judge hereby set aside. Writ petition civil 13457, is it? 13457 of 2006 is restored to the file of the learned single judge in the roster bench, where it will be listed for directions on 7th December 2022. Pleadings are already complete?
Yes, yes.
Since the pleadings already complete in the writ petition, the learned single judge is requested to proceed to dispose of the writ petition on merits as expeditiously as possible, preferably within a period of 6 months.
But
that interim order which is there, that will to continue.
Yeah, the interim order in the writ petition would continue till such time.
And one submission. If a review is not maintainable because the non-available grounds on 7B, somebody files a
Writ
review.
petition will be dismissed on merits then. If the single judge agrees with the commissioner, he will also dismiss the writ petition.
No, I am not saying that. That will open a floodgate, my lord. That you file a 7B non-material 7B.
What floodgate for what?
What I say? It is non-material because appeal is the alternate remedy there. Appeal.
Sir, as far as High Court is concerned, there's only floodgate.
No. The alternate remedy is bar for several cases my law held. Appeal go to appeal. You are 7I appeal appellable order 7B orders appellable 7I.
This, how do you understand the parenthesis, sir? It says except an order passed rejecting a review.
My humble submission
you have
is
to interpret that.
In spite of 7A being rejected on 7A3 because not available grounds, still appeal on 7I is appellable under the 7I. 7 order is appellable.
So your best argument you reserve after the order is dictated. Always.
I have said that.
Because then the council is fully conscious now of what the issue is. Judges thinking.
I'm not saying.
So your full vigor, once the order is dictated, full vigor starts.
I stated that from the beginning.
Which is why you'll notice review petitions are so well drafted. Because the judge has neatly put out the facts, put out the law. Now the council is fully clear now.
I am not saying.
So review petitions are very well drafted usually.
For milers of kind of consideration, if 7B not mental 7A is filed, get rejected, then I will not 7A order, I will not challenge in the writ. If 7B order is not applicable, but 7A order, 7 order is still applicable. This is a privilege on 14 and file an appeal.
All right.
Supplementary item 35.
May it please another matter. Here is the case, the Union is a petitioner and against the order of Honorable Single Judge dated 19/12/2017. The Union is preferred to file an appeal challenging the same on the ground that after exhaustion of appeal, thereafter revision, a constable who was appointed in the CRPF by suppressing the material facts and he has joined in the temporary service, basing on which the Rule 5 was provided to permanent service, against which he has preferred the writ petition before the Honorable Single Judge and an order was passed. This may I pray, my lord, can it be taken up some other day?
All right. At the request of Mr. Padi, learned counsel appearing for the appellant. It's on 20th February. 20 February.
Item
Mr. T.R.
36.
Mahapatra may be reflect along.
All right.
Item note 36.
Account भी नहीं.
None of it is dismissed.
बड़ा पड़े नहीं.
36.
Speak to the mic, madam.
My lord, the brief has been transferred.
All right. So the counsel states brief has been transferred. None appears dismissed. All right.
Item 37.
None appears dismissed.
Item note 38.
Delay.
This is a matter for appointment order rehabilitation assistance scheme. There is a delay of 15 days in filing the appeal.
All right. Delays condoned. All right. This is the same issue.
No, that is something different. My lord, my father died. This is the daughter. The mother was there, but she was staying separately. But when she applied for appointment, immediately within time she had applied for under the Odisha Legislative Assembly, the claim was rejected because she could not produce that. The Tahsildar has not given that certificate, income certificate, because there was some family dispute with regard to the property. And they insisted upon Rule 2 of that rehabilitation assistance rule at the relevant time, wherein it stated that the family disputes has to be resolved. Thereafter, only the process can be made. And accordingly, a suit was filed, and suit was decreed in favor of the family partition was accepted. That is at annexure 2, and thereafter, again I pursue the matter, but that claim was not accepted. I went to the Honorable Single Judge that now I am the only daughter and can get an appointment on a rehabilitation assistance scheme. The Single Judge has said no. By referring to that Rule 2, again, because the family partition and family arrangement was not made prior to the death of the father, so you are not entitled to. But my submission is before the death of father, son cannot get any benefit. Only son disputed with regard to this with the sister only after the death of the father. It was filed. And civil suit made the partition. Thereafter, a place, very small landed property they have. They don't have a residential house also. But because of that,
No. What is Rule 2 explanation? Let's read that first.
my lord, that is quoted in that order itself, page 24, annexure 5.
That's right. Page 34.
Page 24.
All right. Again,
Yes.
I think repeated maybe.
Repeated by the, yes. It says, income of an earning member will be taken into account for the purpose of assessing the annual gross income of the family if his separation from the family has not been established by registered partition deed made prior to the death of the employee. This is the only problem. The son was there. Son had some income, but she was saying during the lifetime of the father, she was staying separately. But suddenly father died in 2012. Because of this, son was having separate family, staying separately, apart from the family entirely, the dispute arises. Therefore, the civil suit was filed. And the son has no share to the property unless the father, when the father is alive, the father's property he has nothing to do. So then only the suit was filed by the mother and myself. And decreed in our favor. This is the only peculiarity.
No, if the suit is decreed, then your earning income has gone up then.
Pardon me?
Your annual gross income of the family must have gone up, no?
No. That is not. Only partition was settled. Family arrangement. That order I have given also. Only partition, no income to that effect. Only see the order person. Page 16 of the brief. Order passed in the suit. The suit B and same is hereby decreed in contest against the defendant under the circumstances. Defendant is the brother. Under the circumstances without any cause, the family arrangement settlement dated 21/12/2011 is declared to be genuine, legal, and has binding effect on the defendant. The right, title, interest of the plaintiff over the suit property are hereby declared, and their possession thereof is confirmed. The defendant is hereby permanently restrained from interfering in the peaceful possession of the plaintiff over the suit property. During the father's life, father died in 2012, March 2012.
No, but you did not apply for.
I have applied. That itself in Annexure 5, they have admitted.
On 12th September 2012.
Yes, within time I have applied, within 1 year. So this is the only peculiarity, my lord. Father was a class 4 employee, and I am also ready and willing to join as a class 4. This is the only.
When was the suit filed?
Pardon me? That is after the death of the father. That is admitted well, because when this family partition worked during the father time, he has said that you are deserted, that is a son. 2011 says driving out, but this legal aspect could not be processed at the relevant time. That is the difficulty we face now. That is why the suit was.
It's returnable. First February. All right.
Item note 39.
May be permitted to take some copies on the state.
All right. Council, additionally, copies be served on council.
No, they are saying they will not accept notice. I will take notice.
All right.
Item note 39.
Yes, my lord, no.
111 days delay, sir.
My lord, delay, my lord, due to the fact that the petitioner was suffering from different kind of diseases, was out of station. So he could not come up, my lord.
No, that's all not convincing, sir.
Your lordship, kindly see the round I have taken.
Yes.
In the
This is all not a ground, sir. Hypertension means blood pressure.
Yes,
1 in 3 Indians suffers from BP.
A 77 years old man.
Whatever, sir. These are not reasons for delay. There's a delay of 112 days in filing the appeal. The explanation offered in this application for the delay is not convincing at all. The court is accordingly not persuaded to condone the delay. MC number so and so is dismissed. Consequently, the appeal is dismissed.
Item number 40.
My lord, here in the writ appeal, the issue is involved that whether the widow, whether the mother is entitled to get the service entitlements of the deceased son. My lord.
Whose wife? This is the wife.
My lord, here the mother has come up claiming
So
that
not served that respond number 5. The main contestant is not served, sir. And you are appearing?
No, I'm for 1 to 4.
Fresh note. You see the address is wrong. Refused. Oh, unserved the report refused. Refused, it says, so we'll deem it to be served.
My lord.
It's been returned refused, so you'll have to deem the service complete. All right, you proceed.
My lord, can I say something, my lord? In this matter, that what I have researched, my lord, in 2016 Supreme Court judgment, my lord, they have settled the issue in favor of the widow, my lord.
Correct.
Mother is not entitled.
Correct. That's fair enough. No. All right. Right. Yeah. Fair enough. We really appreciate that. You say the impugned order of the single judge has decided that it is the widow and not the mother who would be entitled to the family pension of the deceased servant. That is in consonance with the declaration of law by the Supreme Court in Neetu versus Sheila Rani, 2016-16 XCC 229. Accordingly, the court is not inclined to interfere. The appeal is dismissed.
Item 42.
None appears dismissed.
Item number 43.
None appears dismissed.
Supplementary list, item 44.
your lordship. Item 41.
40?
41.
That was adjourned by mentioning. Give him the date.
12th December it is coming. Item 44.
My lord and senior is ill, my lord. This matter may kindly be taken up 1 week
All
after.
right, counsel for the
In the
appellant
meantime-
stated to be unwell.
In the meantime, I will remove the defect.
All right. This one. In January, defects be removed in the meanwhile.
Item number 45.
My lord, this appeal is against the order passed by the Honorable Single Judge, order dated 24/8/18, wherein the Learned Single Judge has dismissed the writ petition without assigning any reason, my lord. Lordship, the impugned order is at page 30, my lord. And before Lordship will glance through the impugned order, Lordship kindly have a glance to page 19 of the writ appeal, my lord, wherein the petitioner has been at the quarter and subsequently he was allowed to return the quarter as because his dues has not been paid, because in the year 2001, the petitioner in which the petitioner was working, the spinning mill was privatized. It has been sold away to a private company. So the land is not coming within the purview of the public premises. And when he has been allotted with the quarter, the question of unauthorized occupants will not arise, my lord.
No. Are you still occupying the quarter?
Yes. I'm occupying.
Despite dismissal of the writ petition.
My lord?
Writ petition got dismissed in 2018 itself, no?
My lord. Then thereafter, before this appeal, my lord. And appeal, there is interim order has been passed.
Where is that?
Lordship, I exactly not remember the date, my lord.
Yes, my lord. There is a 16th April 2019.
Status quo.
Status quo has been passed. And thereafter, till then I am continuing, my lord. Lordship kindly have glanced to page 19.
This is unreasoned order, sir. Single judge, no reasons discussed at all.
But the so-called allegation of the
Then you here then either you file a counter here or it has to go back because
That
single
is,
judge.
your lordship is correct that no counter was filed, but still.
No, and no reasons in the single judge. So I'm saying if you want
What
us
is
to
his
decide,
ground? His ground is that I have not been paid with my dues, so I will return the quarter. This is highly unreasonable and unjustified.
My lord, lordship kindly glance to the
If
definition
he
of
has not been paid with any of his legitimate dues, then the forum is different.
my lord, admittedly, company proceeding is pending before this honorable court.
Sorry?
Company proceeding is pending before this honorable court.
You must have retired, no, sir?
It is.
I have retired, my lord, but I have raised my dues before the official liquidator.
No, but how does it?
And my lord, moreover,
That
admitted.
means official liquidator will keep it for so many years and will enjoy.
My lord, lordship kindly glance to definition of public premises. When the meal has been privatized, sold away to the private company, the question of public premises will not arise, my lord.
But be that as it may, it
Lordship
is not
kindly-
your house. It is not your private house.
Lord, kindly glance to the definition of public premises. There is, my lord, two.
So why did you implicate the government as a party to the writ petition?
Yeah, exactly.
My lord, order has been passed by the government, my lord. Because
The government
proceeding has been
matter.
initiated by the government and by the state officer, the sub collector and the collector, my lord. And the order has been passed. The order of the collector is under. Lordship kindly grants the definition of public premises, my lord. 2E, my lord.
This is a spinning mill. Spinning mill has already been taken over, and government is the owner. It is a government property. You are in occupation. You are already retired,
It is not
and
a
you have
government
already enjoyed the quarter
My
for
lord,
a long period.
My lord, initially,
You have some dues. Okay, if you have got some dues, you can recover it. And you are also saying that I have approached the official liquidator for getting my dues. But how can you?
Even after we dismiss this writ appeal, he is going to continue the quarter.
my lord,
No, that is a different matter.
Lordship kindly glance to page 20, my lord.
No, this time the government will.
Lordship kindly glance to page 20. This is the arrangement made.
Because it will encourage other illegal
Lordship
occupants.
kindly glance to page 20, my lord. The arrangement made between the IDCO and for the occupation of the quarter. My lord, page 20, my lord.
Sir, all this holds good as you're in service. Now that you've retired long ago, you have to vacate.
My lord,
As simple as that.
my lordship kindly glance to page 20.
You're getting this allotment only because you're an employee.
My lord,
Let's not
my lord,
forget that basic fact.
My lord, Annexure 2 shows that.
Anyway, you have to vacate the quarter. So let's not, don't be unreasonable.
If my dues
if you want some time, we're prepared to give you. If you say give me 3 months time, 2 months time, that's different.
Lordship,
If you insist, no, I will continue because my dues are not paid, then you don't have a case.
Lordship,
And dues to be paid by the official liquidator.
Correct.
Lordship, on this observation, dispose of
Sorry?
6 months time may be granted, my lord. 6.
You file an affidavit undertaking, all right?
And my lord, counter is to be filed, my lord.
No.
Don't go that route.
Your
sir.
lordship may direct that he will file an affidavit before the collector that within such and such period to vacate, and accordingly the appeal may be
Lordship,
disposed.
kindly glance to page 20, my lord. Just bear with me, my lord. 1 minute, my lord. Page 20.
Then you won't get this benefit of time. Let's make it clear to you.
Lordship, then I will file affidavit within 2 weeks, my lord.
Yes, that is okay.
All right. The challenge in the present writ appeal is to an order dated 24th August 2018. Passed by the single judge dismissing. Writ petition civil 8270 of 2018 filed by the present appellant. So stop with the said writ petition. The appellant had questioned the order passed by the sub-collector cum estate officer Sonpur on 16th July 2012, as well as the order dated 2018, passed by the collector Sonpur, ordering the petitioner's eviction from under the Orissa Public Premises bracket Eviction of Unauthorized Occupants Act 1972 bracket Act, ordering the eviction of the appellant from the quarters allotted to him that is quarter number C-1, officers and staff colony, Sonpur, by virtue of his being employed in the Sonpur spinning mill, bracket, mill, paragraph. The admitted fact is that the mill, on becoming sick, was taken over by the government of Orissa. Full stop. Admit. No, forget that. Just you say. It appeared that by the time the eviction was ordered of the appellant, the mill had been sold in proceedings under the Companies Act to a private entity. Full stop. However, the appellant himself has superannuated in the meanwhile, and therefore there can be no justification for his continuing in the quarters. Paragraph. Counsel of the appellant then contended that some dues were still owed to him, and therefore he had a right to retain the quarters till his entire dues were paid. Stop. The court is unable to accept this plea. Full stop. Since the issue concerning the Sonpur spinning mills is already before the judge, the dues of the appellant would have to be considered and settled in those proceedings. That cannot be a ground for the appellant to continue occupying the quarters allotted to him once he has attained the age of superannuation. Paragraph. Consequently, the court is not inclined to interfere with the impugned order on a single judge. Paragraph. Counsel for the appellant then pleaded for some time for the appellant to vacate the premises. Stop. It is directed that, subject to the appellant filing an affidavit of undertaking before the collector Sonpur within 2 weeks, that is on or before 9th November 2022, undertaking to hand over peaceful and vacant possession of the quarters in his possession on or before 31st March 2023. The petitioner will be allowed to retain the quarters till then, subject, however, to his paying the requisite penal charges and rent up to date. Full stop. It is made clear that if the above affidavit of undertaking is not, full stop, the appellant will further undertake not to part with possession to any third party and to also not create any encumbrance on the quarters in question. Full stop. It is made clear that if the aforementioned affidavit of undertaking is not filed on or before 9th November 2022, the
respondents will enforce
the quarters would, it will be open to the respondents to straightaway take over possession of the quarters in question. The appeal is disposed of in the above terms.
Item number 46.
May I please?
Delay.
That I am challenging the impugned order at annexure 5. And it is a dispute arising out of the
117 days delay, sir.
117 days delay, I have explained, Lord.
Let's see that.
That because he was an illiterate villager and that was not communicated to him. The dismissal was not communicated to him after knowing the same, and he came and filed the appeal.
What's the matter about?
That the fact is that the property was purchased in the name of the grandmother of the petitioner's blood. And it is accordingly recorded in the name of the mother.
Is anyone appearing? You're appearing for the...
No, I'm appearing for the private party.
So, and your lordship can see annexure 2. My lord Justice Das can see, Lord. That is in vernacular. That annexure 2 at page 13, Lord. Your lordship can see. 13, it was admittedly recorded in the name of the mother of the petitioners under Sthiti 1 status. And in the remark column, your lordship can see there is a noting that some persons are in forcible possession at page 14.
This is a consent order.
And thereafter, please, but it's not a consent order.
You're all related to each other.
No, they are not related. They have created disturbance in his possession. And your lordship, there is a government circular. There is a clear government circular that forcible possession should not be recorded in the record of right. Because only the person who has the title over the property, his or her name should be recorded, and there should not be any forcible possession. That is the circular issued by the government on 13/7/1987. And on that basis, he filed the revision to delete that portion of forcible possession, and since the property has been recorded in their name. And the commissioner allowed that. They have the title, they can establish in the civil court. And the commissioner had not committed any error, or he has not passing the order, he has not committed any jurisdictional error by correcting that portion. And the non-single judge has observed that since the question of title is involved, so therefore the commissioner had no jurisdiction to go in the question of title. Commissioner has only directed that the noting made in the remark column that should be deleted, because it is in accordance with the government circular. Your lordship can see that is the government circular at 13/7/1987. If you have title, then you establish your title before the civil court, and the person who has been recorded and as the title holder, he has come to the commissioner for recording for correction of the ROR, that portion of the ROR under section 15B. And the commissioner has the jurisdiction under section 15B to go into that question according to the government circular. The commissioner has not committed any jurisdictional error in going to the question of correction of the record of right of the remarked person. And if any title, the other side has any title over the property, they can establish that title before the civil court.
You have not filed any counter in the writ petition?
No, I have.
You were to file the counter, no? It was his writ petition.
That the counter at the stage of admission, it was disposed of.
Oh.
No, my lords, may I just show the order?
And your lordship can see there is no consent. In the order, there is no consent.
My lord may see the order at page 30 of the writ appeal.
Right.
The writ para 2, the writ petition involves a challenge to the order dated so and so passed by the learned additional commissioner so and so. Above that, the names of the councils are written. I was appearing for the petitioners, Sri A.K. Mishra for the government, and Sri G. Satpathy, learned counsel for opposite party numbers 2 to 6. And then, my lord may kindly see, the specific question raised was that question of title cannot be gone into by the survey settlement authorities. And then below that, para 4, Sri A.K. Mishra, learned advocate, as well as Sri Satpathy, learned counsel for the opposite party numbers 2 to 6, has no dispute to the legal position involving the matter.
I have noticed. No, that's different from saying that what he wants simply a correction of certain remarks.
Well,
see that the settlement commissioner will not decide right title interest and relegate parties to civil court is understood.
My lord.
But whether the settlement commissioner can correct certain remarks in the columns in the ROR,
that's
a different issue altogether.
That's circular of the government.
No. In this case, there was a civil suit pending inter party that was annexed to the writ petition. If my lord would see the writ
your lordship can only say that civil suit proceeding of will not be influenced by this correction.
Yes. That can be passed.
No, civil suit. In any case, civil courts are not influenced.
Because it's
coming from my learned friend. Civil courts are not influenced by the ROR.
Yes.
No, ROR neither creates title.
Yes. In any case, this writ appeal is misconceived, my lords, because in case they succeed in the civil suit, the ROR will abide by that order.
The suit is filed by them.
Suit is pending.
No.
We have not filed the suit. They have filed the suit.
Yes, suit is filed. In case they succeed in the suit, then this ROR will go. That is the law, my lords. So in this way,
the ROR has been corrected by on the basis of a circular and the policy decision of the government. And the commissioner has the jurisdiction.
And if that has been corrected, that will not extinguish the title. If any person has the title, his title will not be extinguished.
No, no. How is this not correcting the entry in the ROR? How is it affecting you?
Blood affecting you because they are interfering in my possession by taking advantage of that entry, blood.
No. Since you've gone to the civil court, you could have asked for an interim injunction.
Interim injunction there, blood. If a person has been recorded, that is the policy decision of the government. And
right now you're in possession.
Yes, blood.
So they're not interfering.
We are in possession over the property, and we have
so even after, so basically even after this petition was allowed,
for a moment that circular.
No, 1 minute. I just want to know factually, even after this writ petition was allowed on 9th July 2018,
yes,
you continue to remain in possession.
I am
so we will
continuing
clarify that the status quo be maintained till the suit is completed.
Set aside. Yes,
that will serve your purpose.
Status quo
that will solve the suit is decided.
Yes,
I won't stand on the way of all this, but my lord, may I submit one thing? This is a matter under the Survey Settlement Act.
Correct.
That is basically an issue of revenue, and these record of rights are issued only for purposes of collection of tax. They don't deal with questions of title. Now, if they want...
His only apprehension was because of that entry in the ROR, his position was getting disturbed by your party. That's what his apprehension
in case
was.
that kind of... On that basis, I have approached the commissioner.
The commissioner doesn't have a power to grant injunction.
So correct. So all the more then, therefore he has to go for only a civil suit.
Yes, my lord.
You have gone for his...
in my civil suit also, he can pray for injunction.
Correct. So instead of actually getting parties to do all that, you agree that status quo will be maintained till the suit is decided.
Now, my lords, if status quo is passed in this writ matter, then that would be usurping the power which is not vested with the settlement authorities in any manner.
Or we'll say that he'll file an application for interim relief in the suit. Till it is decided, status quo be maintained.
No, my lords.
Either way, I'm just saying, since you are anyway, even after the allowing of the writ petition.
No, this allegation.
This was your writ petition, correct?
My lord.
So it was allowed, but despite the writ petition being allowed, you're not in possession, he's in possession.
That is his claim, my lord.
You want to take instructions, you take instructions.
I'll take instructions.
All right.
There is no prayer for injunction in this writ of law.
All right. Counsel for the appellant asserts that the appellants are still in possession of the property in question. On this submission, Mr. Gautam Vishal and the senior counsel wants to take instructions.
My lord.
Full stop. List on.
Your lordship, fix up.
Here, there's no interim order.
No, there is no interim.
There is no prayer for injunction.
There is prayer for injunction also.
All right.
Because
then it will come on 24th January. All right.
The only question involved whether the commissioner had the jurisdiction to correct that entry.
All right.
That is the only question.
All right.
To be decided.
Orders item number 1.
May please, my lord.
Yes, please.
Yes, my lord, I filed this review application
Yes.
for revision of order dated 30/21, my lord.
Correct.
Then, my lord, my ground is certain facts have not been brought before your lordship. With the due diligence, the petitioner would not brought certain facts before your lordship, and the order itself shows that that has been not passed on merit. Lord, I'm supplying a short notes of
See, you've not implemented. You're now seeking review of our order, right? You're now seeking a review of our order.
My lord.
You have to now tell us what is wrong in our order.
My lord, certain facts could not be brought in the writ appeal, my lord.
No. You have to now, that stage of bringing facts in the writ appeal has gone because the writ appeal is itself over now.
My lord.
We have passed an order dismissing the writ appeal.
My lord.
What is wrong in the order that we have passed that you have to show us?
My lord, my only ground is that the order was not passed on merit, my lord.
No, that can't be a ground for review, sir. That can't be a ground for review. You had a chance. It's not that it was passed ex parte. You were heard. After hearing you, an order has been passed. You have to show us what is wrong with the order that has been passed.
My lord, para 4 of the order, my lord, considering the respondent number 1 is a pensioner and 81 years old, and given the attitude of the present appellants, the court considers it is not to be in the interest of justice to interfere.
Correct. Is it wrong? Is it wrong? Is he not 81 years old? And you have not implemented it till date. Just come to para 2.
My review application, my lord.
No, para 2 of the order that we have passed. Is it not right?
Yes, my lord.
You're not even implementing it. You are not implementing it. He has not filed a contempt.
And your lordship has passed para 5.
No. What is wrong in para 2, para 3? Anything wrong in para 2 and para 3? Or in para 4?
Para 5, my lord. Para 2, 3 is all right. Para 5, consequently leaving all the questions of law that might arise from
Correct. What is harm you, sir? A man is 81 years old. He has not filed a contempt. You have not implemented. Nothing is happening.
My lord, he filed contempt thereafter, my lord. After disposal of this writ appeal.
When did he file? Where have you said that?
My lord, I have filed.
Where have you said that?
Contempt, my lord, I have also filed an IA for stay of the contempt petition.
When did he file the contempt?
Contempt number 6964 of 2021.
Where have you said that in your review petition?
Review petition, my lord, I have filed an IA with the review petition.
So you have to aver it as a fact, isn't it?
In IA, my lord, I have mentioned.
Even there, you do not say that he filed a contempt petition after the disposal of the writ appeal by us. Even that you have not mentioned. You have not enclosed a copy of the contempt petition.
In this case, my lord, the petitioner has already taken the retirement benefits, and thereafter again he come up for pensionary benefits, my lord. Retirement benefits he has taken, and there was a scheme which he claims.
They're asking you something else, you're answering something else. Where have you placed on record a copy of this contempt petition?
I've only mentioned the number of the contempt.
That is not helpful, sir. You have a copy of the contempt petition with you now?
No, my lord. I will amend, my lord, then.
Counsel for the appellant petitioner states that the respondent has filed contempt case number 6964 of 2021, but he does not have a copy thereof and undertakes to produce it on the next date. When is that contempt petition listed? You're not aware?
No, my lord. At the time of filing of this,
It's disposed of. He says it's disposed of, the contempt petition.
my lord.
What are you saying, sir? You're not even telling us the correct facts.
My lord, one contempt petition is pending because, my lord,
That number which you have given, he has checked up. Just see, we are getting the order now. Are you aware that you can go on the net and get orders?
my lord,
We've got the order now. Just show us the order.
my lord, in that contempt petition might be without issuing notice that has been disposed of by
How is it affecting you then, sir? How is it affecting you? You are asking for stay of a contempt petition which has already been disposed of. You have not even bothered to find out. Anyone appearing for the respondent? Mr. Sattar, are you appearing this matter?
My lord, subsequently another contempt application has been filed, my lord.
Yes, my lord. We are appearing in the contempt.
This is very different, sir. This is within 3 months. That's it. What are your instructions, Mr. Sattar?
My lord, another contempt we have filed after the order of writ appeal. Contempt number 53362 of 2022.
All right. In that case, because we had passed that order in the writ appeal on the basis that you have not filed any contempt because he was unable to tell us, the counsel.
My lord.
Now it is clear that you are filing not one, you have filed a second contempt petition.
My lord. My lord, after the...
So then we'll restore the writ appeal. Let it be heard on merits. All right. You see, counsel appearing to the respondent confirms that earlier contempt case number
5382, my lord.
6964 of 2021 had been filed, which was disposed of by the learned single judge on 3rd December 2021, giving the appellants here, appellant/review petitioners 3 months' time to implement the order dated 21st December 2018 of the learned single judge in writ petition civil 17280 of 2018, against which the present writ appeal was filed. Full stop. It appears that thereafter a second contempt petition being contempt case number
5382, my lord, perhaps.
Five three 5382.
My lord, he just said.
You have to unmute yourself, sir.
My lord, 5362 of 2022.
5362 of 2022 has been filed. Paragraph. This court had, in its order dated 30th October 2021, proceeded on the basis that the respondent had not filed any contempt petition, which obviously was incorrect. Full stop. On that ground, the order dated 30th October 2021 hereby recalled, and writ appeal number 111 of 2019 is restored to the file of the division bench for being disposed of on merits. The writ appeal will be now listed before the roster bench of the division bench, roster division bench, on 14th November 2022, on which date both parties will appear. All right. The review petition is disposed of.
Supplementary list item 47.
47 is infructuous, my lord.
All right. Dismissed as infructuous.
Item number 48.
E8, my lord.
Yes.
I am for the appellant.
Yes.
We are in Odisha, OSATs, my lord, road transport corporation, my lord. Initially was appointed on regular daily.
Didn't you mention it for adjournment?
Yes, I mentioned because I have in happens, my lord. I have two hearing matters in.
It's all right. Then we'll have it on some other day. No problem. Counsel for the appellant is stated to be in some difficulty. It's on 2nd February.
Item number 49.
May I please, Your Lordship?
Yes, please.
Well, this is a matter regarding delimitation of wards in a Gram Panchayat. And this matter was earlier before this Honorable Court, and Lordship directed for consideration of my objection, which was filed under section 83, 81, 82 of the Gram Panchayat Act. And that was considered by the collector, but that was considered on irrelevant ground and saying that no personal hearing is necessary, so that is not given. That order is at Annexure 5. Lordship kindly turn to page 24, Annexure 5. The grounds he has taken for rejection, I am reading it out, the relevant person, and whereas after re-examination of the delimitation process, as per government norms, it is found that Sonijanga Gram Panchayat into 16 wards is done as per section 81 of Gram Panchayat Act 1964. Instruction received from the government in Panchayat Department, Odisha, by letter dated so and so. This letter is to reorganize, delimit the keeping in view the geographical barrier and basing on total population of Gram Panchayat. There is no geographical barrier at all. I have given the map. There is no geographical barrier at all. But that has been indicated here.
No, but the single judge has, no, the single judge has simply said that you cannot come at this stage, you can come later. The single judge.
The order itself speaks that I have earlier, but in the meantime, Gram Panchayat election is held. So that will not make that will.
After this order, once the Gram Panchayat election has already been held,
no, this
he
is
has
not
never raised this question as a liberty has been granted by to the petitioner by the honorable single judge. He has never moved the before single judge raising this is put soon before the last election.
No, this is not for the purpose of election. Nor that once election is held, my case will be infructuous. It is not that. My case is regarding delimitation, not for only one election, for future also.
So it can be sent back to the single judge now that the election is over.
So that should have been considered. But this is not maintainable.
All right. You say now that the Gram Panchayat elections have already concluded, the bar of entertaining the writ petition challenging the delimitation.
Yes,
does not arise. Consequently, while setting aside the impugned order of the single judge, this court restores writ petition civil 18774 of 2018 to the file of the roster bench of the single judge, where it will be listed on 3rd January 2023. The state will file its parawise reply to the writ petition. Who are the parties in the writ petition?
Party to the collector.
The opposite parties will file, the respondents bracket opposite parties in the writ petition will file the replies to the said writ petition on or before 19th December 2022. And rejoinder thereto, if any, will be filed before the next date, that is 3rd January 2023, before the learned single judge. No further time will be granted for this purpose. The learned single judge is requested to proceed with hearing the petition on merits and disposing it of as expeditiously as possible.
Obliged.
Item number 50.
Lord, in this case, my
the two respondents, 4 and 6, are not yet served. That it has come back saying not received, and the other it says addressee left without instruction.
Yes, my Lord, may I be allowed to file notice too?
All right. The appellant will ascertain the present correct addresses of respondents 4 and 6 and furnish the registry within 4 weeks. Thereafter, fresh notice be issued. by registered speed post, returnable 18th January 2023. The tracking report be placed in record.
Item number 51.
92.
Time for respondent number 5, madam.
In this case, the petition challenge the input data on class by round of single judge Miller by the annex 6 is 30 to 35 Miller. The honorable single judge, without touching the merit of the case, they dismiss the case on the basis of limitation Miller. The background case like this Miller. The petitioners and opposed by 2 and 2, 3, they are the record attendant and as per the annex 1. But when the petitioner is minor, his land has been allocated by his mother, and the petitioner challenged the cell leads on section 34 of the OCS People Act 1972 before the collector. And the collector passed the order that there is a delay. And also the cell lead that is not a cell lead, that is a mortgage deed. Actually, the recital of the cell lead deed itself said that there is a cell lead, not mortgage deed. And the person, the father of the patient operated for, neither a continuous
20 years delay.
The father
25 years.
Delay of 20 years, that's what the single judge says.
Yes, Miller. Delay means from the data majority, that is finding of the single judge.
Yes, that's right. After attaining majority, waited for 20 years.
But from the data of acquired knowledge, the petitioner acquired knowledge on 1/5/2017. There are challenges for the collector on section 30 of the OCS Bill Act Miller. And what actually the father of the opposed party 4 is neither a continuous choke holder, not a co-sharer. He has no right to purchase the land by fragmenting the choke, for which section 34 and 35 Act of Constitutional Act is violated. But only the case has been dismissed on the technical ground that the petitioner failed to challenge the cell lead within 3 years from the date of majority. But since the cell lead is void, that should be avoided, and that should be declared. That should be.
You can't have a self-declaration that you came to know only 3 years before, sir.
But as we kind of answer 3 Miller, answer 3, the family petition. As per the family petition, the other courses say that the land has allotted in favor of the present petitioner. There we inquired the matter and found the land has already sold by his mother, for which the challenge is for the collector. And in the meantime, the father of the opposite party 4 died Miller. And thereafter, the Vijay Das, whose name the land has recorded, he has challenged this immunity party. The made a challenge the columns. The challenge there said for the collector. Collector hold that. The petitioner failed to challenge within 3 years from the date of majority. And also section 34, 35 of the Act has been violated. My submission is that since the father of the opposite party purchased the land, he is never a continuous choke holder. So he has no right to purchase the land from the one of the co-sharer by fragment choke. Only technical account the case has been dismissed.
The challenge in the present appeal is to an order dated 27th August 2018, passed by the learned single judge, dismissing writ petition civil 12255/2018. Paragraph. By the said writ petition, the appellant had challenged an order dated 30th May 2018, passed by the collector Balashore in consolidation case number 11 of 2017, rejecting the prayer to declare the registered sale deed dated 13th April 1991 as null and void, and the consequential prayer to evict respondent 5 from the suit land. Paragraph. As noted by the learned single judge, the mother of the present appellant sold the land in question to the father of opposite party number 5 by the aforementioned registered sale deed. Full stop. Even accounting for the fact that the appellant was a minor at the time of the registration of the sale deed, he attained majority in 1997, and yet he filed the application before the collector only in 2017, after 20 years. Paragraph. Counsel for the appellant sought to argue that the appellant became aware of the sale only sometime in 2016 May. May 2017 or 2016? 17, May 2017. However, this is a self-serving statement which has not been supported by any affidavit of anyone else.
The answer 3 I have given family petition. I have given answer 3 family petition.
No, there's no affidavit of anybody. Consequently, the learned single judge could not have gone by the said self-serving statement. the fact remained that the challenge was laid more than 20 years after the appellant attained majority. And therefore, it was clearly barred by laches. No ground made out for interference. The writ appeal is dismissed.
Supplementary list fresh admission item 52. Item number 52.
May I please, Lordship? On behalf of Mr. K.K. my Lord, no instruction.
No instructions dismissed.
Item number 53.
Not present. Not present. Right.
Item number 54.
None appears dismissed.
Item number 55.
May it please, my lords. This is against the order of the National Green Tribunal, my lords, dismissing the application on 8/9/2022, wide, my lords, annexure 4. And the trigger was page 119, annexure 3, my lords. The collector Dhenkanal was given a representation. The representation, as your lordship can find at page 120, has been signed by sarpanches of 4 gram panchayats who have opposed the setting up of clusters in petrol pump, my lords. So this issue was carried to the this is in violation of the MORTH guidelines, Ministry of State Road Transport. That guideline, no doubt, my lords, the lordships have held in our High Court and other High Court that they are directory, not mandatory. But the issue that was canvassed before the tribunal, my lords, was different. The issue was that as far as setting up of petrol pumps in a cluster is concerned, there are already a direction of the National Green Tribunal with relation to the urban centers, that in the towns and within the busy cities, you can't have clusters. But similar directions were sought for with regard to setting up on the highways. And also, second issue that was canvassed before the tribunal was this, that since tribunal has already recognized earlier that petrol pumps have been causing benzene pollution, and petrol pumps are liable for environmental hazards, so they should be subjected to some kind of checks. So since this has already, the tribunal has gone that far, it was urged before the tribunal that you bring it within the environmental impact assessment notification, to make the environmental impact notification applicable to these clustered petrol pumps. That was the issue. Your lordship finds that this is the larger issue that has been raised. Your lordship finds that in paragraph 120, page 124, 3 prayers were made.
Right.
Page 6. The reliefs claimed in the present original application reads as under: direct the opposite parties to mandatorily conduct an environmental impact assessment under EIA notification 2006 for new petrol pumps. Direct the opposite parties to mandatorily implement the requirement of environmental clearance before setting up of new petrol fuel stations. And direct the opposite parties to declare the guidelines issued by the Ministry of Road Transport and Highways circular as mandatory compliance for sitting of fuel stations under Annexure A2 series, my lords. Now, this was, my lords, addressed by the tribunal at page 127, para 15. In our opinion, tribunal said that since proceeded on a tangent, refused to address the issue, saying that since this is not covered under the Environmental Act, the MORTH guidelines are not covered, so we would have no jurisdiction. You can move the appropriate forum. I'll place that paragraph. In our opinion, unless violation of the environmental norms can be shown by the applicant, this original application would not be maintainable before the National Green Tribunal, being a court of limited jurisdiction concerned only with violation to environmental norms. If there is a violation of sitting criteria under the Government of India Ministry of Road Transport and Highways, that would not fall within the jurisdiction of the National Green Tribunal, and the applicant would have to seek a remedy in this regard before the appropriate forum. For this purpose, the National Green Tribunal is not the appropriate
So you have
forum.
not pointed out what is the environmental pollution caused by the
Environmental pollution, my lords, I have pleaded, your lordship will see. The earlier, my lord, environmental pollution caused by petrol pumps is not a new thing.
No. This particular petrol pump. You have to say, you see,
Well, I am not against this particular, the larger issue that has been canvassed here. I am not
it's
against.
not like a PIL, please. I mean, you can't have a general roving kind of a thing that all petrol pumps all over Orissa, is it directed against all petrol pumps?
This is my canvassing is to lay down the norms that it should come under the environmental.
Completed respondent number 9. Come to para 9.
My lords.
Page 125. You've implemented a certain party.
My lords.
You've not projected it as some PIL or something.
No, the PIL would not lie in.
That's right. So I'm saying this question of just going to the NGT to generally ask for guidelines, that doesn't arise. Only for specific instances of environmental pollution, you can go to the NGT and ask for investigation.
Such a petition was also filed earlier in the NGT.
No, but as far as this petition is concerned, come to para 9 of the impugner.
My lords. The entire body of the original application, no amendments have been made to show that respondent number 9 by operating the petrol pump is causing environmental pollution. And if so, what is the nature of such environmental pollution? We may note that tribunal original application 31 of 2019 and original application 86 of 2096 was dealing with cases relating to sitting criteria.
Citing criteria.
Citing criteria. Sitting criteria.
No, it's citing.
Citing.
Citing
criteria of retail petrol pumps unless outlets within cities selling 100 kiloliters of oil per month in cities with a population of 10 lakhs and 300 kiloliters per month in cities with a population of above 10 lakhs. Now, similar applications were entertained, but the NGT, similar applications where it was brought to the notice of the NGT. NGT addressed confined.
This is on the highway. See, I think they're making a distinction between citing petrol pumps within cities and citing them on highways. Obviously, the same criteria would apply.
My submission, entire submission, I agree with you, my lords, we are on the same page. My entire submission before the tribunal was this, and also before your lordship was this, that since the tribunal has gone thus far and laid down this criterion for the urban centers, why not have it
but on the basis of some facts, without facts being placed, if you don't tell the tribunal, listen, this retail outlet on this highway is causing this pollution, therefore extend the norms that you applied for cities to also retail pumps in the highways.
Therefore, the trigger is cluster. Therefore, cluster would cause.
See, this is the question of surmise and conjecture does not arise, please. You have to actually place facts which show that this causes pollution.
I'll just draw a thin line here. I'll not press the issue too far, but I'm just drawing a thin line, my lords. The line is an individual petrol pump can cause a manageable. Pollution is caused, but manageable. That is not so deleterious to the environment. But moment you have a cluster, it would just spike the pollution levels.
But this is not a matter for guesswork.
For that, my lords, the sitting criteria is there in the MOTH guidelines, the sitting criteria. At vis-a-vis the environment, my lords, the sitting criteria should be adhered to.
Yeah, all right. This is not inclined, please. The challenge in the present petition is to an order dated 8 September 2022, passed by the National Green Tribunal, Kolkata bench, rejecting the petitioner's original application number 122/2022. The grievance in the present.
If your lordship permits me to approach the collector and place para 11, the facts in place para 11 of my writ petition, para 11 minutes. I've explained in details, my lords, how, my lords, benzene pollution takes place and how, my lords, cluster leads to.
I'll refer to that.
My
You
lord.
say the complaint before the NGT was that respondent number 9 herein was going to set up a retail petrol outlet on the NH55, and that permission had been given for setting it up, although 3 petrol pumps were already existing in the area within a radius of 300 meters. Full stop. It was alleged that this was in violation of the guidelines issued by the Government of India, Ministry of Road Transport and Highways, (MORTH), and an earlier order dated 22nd July 2019 of the NGT, Principal Bench, New Delhi, in OA number 31 of 2019. Paragraph. The NGT noted inter alia that in the entire body of the application, open quotation, no averments have been made to show that the respondent number 9, by operating the petrol pump, is causing environmental pollution. And if so, what is the nature of such environmental pollution? Unquote. The NGT clarified that in OA number 31 of 2019, which it had dealt with earlier, it was concerned with locating or siting, SITING, of retail petrol outlets within cities and not on highways or in the rural areas. Full stop. Further, it noted that if the grievance of the petitioners was about the location of the petrol pump, and they were alleging that it was in violation of any siting guidelines, then the grievance would lay in another forum and not before the NGT. Full stop. In the absence of any specific averments about the pollution being caused, the possible threat to pollution on account of the retail petrol outlet of respondent 9, the NGT was not inclined to issue any directions. Paragraph. Mr. Subir Palit and Senior Counsel submitted that although there may not have been specific pleadings, it is a matter of common knowledge that a cluster of petrol pumps was found to cause pollution. Full stop. These are not matters of conjecture or surmise. Full stop. They have to be specifically pleaded. Full stop. In fact, empirical data would have to be laid in order to make good such an averment. Full stop. This was clearly not done in the complaint filed by the petitioners before the NGT. Paragraph. Mr. Palit then refers to para 11 of the present writ petition, where the possible threats to environment pollution as a result of the retail petrol outlets is generally stated. Full stop. Inasmuch as these facts are being stated for the first time and were not before the NGT, it is not possible for this court to find fault with the order of the NGT in rejecting the prayers of the petitioners. Consequently, the court is of the view that the impugned order of the NGT does not call for interference. Nevertheless, this will not prevent the petitioners from approaching the collector, Baleshwar, Denkanal, with specific details, empirical data regarding the pollution caused by the retail petrol outlets in the area. And after following up on such representation, to seek appropriate remedies in accordance with law. The petition is disposed of in the above terms.
Appearance have been noted.
All right.
Supplementary list for orders item 56.
Collector may fix a date of hearing on within.
Not really. Let you do it first. Yes.
I leave it at that. I leave it at that.
Item number 56.
Grateful.
None appears dismissed.
Item 57.
None appears dismissed.
Item number 58.
None appears dismissed.
Item 59.
None appears dismissed.
60.
None appears dismissed.
Item number 61.
None appears dismissed.
Item 62.
None appears dismissed.
62 is there, Lordship.
All right.
Item 63.
62. This is no instruction.
All right. No instructions.
Item number 63.
63, my lords. The case was on present part is that, my lords, the original application was disposed of. My lords, against that, my lords, the Union of India preferred, my lords, read petition. The read petition was also disposed of in my favor, my lords. Thereafter, the Union of India, my lords, preferred a review petition number 234 of 2017. My lords, that petition, the petition was listed along with that disposed of read petition and the content petition filed by me for compliance of the direction of the Honorable High Court. Now, so unfortunately, my lord, the repetition was disposed of because of non-appearance. Probably inadvertently, that contempt application was also disposed of non-appearance.
For the reason stated, the application is allowed. The order dated 29 September 2022, dismissing contempt case number 1837 of 2017 is recalled, and contempt case number 1837 of 2017 is restored to file. Then in that contempt case separate order, in view of the dismissal of
review petition, manners
filed by the Union of India being review petition
234 of 2017.
234 of 2017. The order under review, that is the order dated 14 September 2017 in OJC number 10101 of 1999 shall now be implemented within a period of 3 months.
My lord, I am for the opposite party. We are taking steps for restoration of that review.
Taking steps for?
Restoration, my lord. That was in non-prosecution dismissal.
That till date has not happened,
Yes.
sir. So we will pass this order within 3 months. The contempt petition is
So let them serve the copy of the contempt application also.
right, sir. Anyway, it's served.
Item number 64.
None appears dismissed.
Supplemental list item 65.
Item number 65. I am appearing through VC. This matter is a review petition, but I would pray that if your lordships can keep it on the 26th or the 27th, because I just have the review petition, I won't be able to assist your lordship with the award. Apparently, there's a tripartite settlement, and this is. Can your lordships hear me?
Yes, yes.
And apparently, under Section 18 of the Industrial Disputes Act, this particular provision has not been considered by the High Court. The order which is impugned in the present review petition. And on the basis of an affidavit filed by the opposite party, the matter was disposed of without looking into the tripartite agreement. Because I do not, probably the writ petition, the main writ petition contains the tripartite agreement. If your lordships can keep it on the 26th or the 27th, I'll be able to post.
Or at the request of counsel for the. You are the review petitioner.
I'm the review petitioner.
List on 25th November. It has to be a Friday.
Could your lordships list us on the 26th?
No, it has to be a Friday, sir.
But I have a bit of a problem. Could it
You,
be on
you choose a Friday of your choice in December.
31st?
No. Choose a Friday, sir. Friday of your choice.
Whether it may be 28th or any other days.
28th.
4 or 11 of the November.
No, not in October.
November is Friday is
November.
4th, 11,
November.
18, 25. Like
No,
this.
let it be 9th December. Is 9th December all right with you?
Very well,
Yes.
my lord. Very
All
well.
right.
Very
All
well.
right.
Let them serve a copy of the same also. This
Or
RPG
Item 66.
all right. Memo. The memo is taken and record. Dismiss is withdrawn.
Item number 67.
My lord, in the case, I require 1 week time, some defect is there, I will give 1 week.
Which one?
67, man.
67.
Is there a defect? Acha. But this is a 2018 matter, sir.
My lord, only the certificate I had filed, but noting is there not filed. I have to just verify. Let it come next week, my lord.
No, let's see what it is, sir. Why hold it up? It's a 2018 matter. You satisfy us right now?
Delay of 98 days in filing the appeal only.
All right. Tell us what the matter is about.
Let it come next week, man.
Why can't you tell us what the matter is?
The order has been passed against the 2 Supreme Court judgment.
So tell us that. Kindly tell us.
But the fact is, he was a probationer. During the probation period, he committed certain overacts and 3 major, 3 punishment was inflicted on him. To the senior, he went to this quarter and threatened him, started to beat him. So at the probation was not extended and that was terminated the probation stage. The Honorable Single Judge held that he should have been given a show cause. On basis of Apex Court judgment in different cases, I placed that show cause is not necessary so far as probationer is concerned, because in the probation period, his conduct was thrice found unsatisfactory and he was served with notice in that. And he is intimated about that. So this is the sole point involved, whether the probationer should be given show cause. As whether it is a case of civil simplicity or that termination will amount to attach stigma.
But you did not implement the order, sir.
My lord?
You were asked to complete an inquiry within 6 months.
That instruction I have to take.
At the request of counsel of the appellant. February 7th.
Item number 69.
There is no delay, ma'am.
All right.
Let's turn to page 10, Annex 1. The impugner. That is regarding that rehabilitation appointment under 2020 rules. And also this.
The Canara Bank.
Well.
So you have to list it after the Supreme Court judgment.
Yes.
Permission to the
Content is filed.
Counsel to the appellant to mention the appeal for listing after disposal of the larger bench matter of the Supreme Court involving the same issue.
A contempt is filed, my lord. In this case, contempt is filed. So that order to is.
Oh. All right. In that case, take it out and say notice. When are the other matters coming up? Any other similar matters? What's the delay here? No delay.
No delay.
That delay you condone it, saying delays during the COVID period is accordingly condoned. Yeah. Then you say notice till the next date, the impugned order shall be stayed. There's no similar matters coming up?
Yes, similar matters coming in February. I was skinned. 1/12. 1st December.
Or 1st December.
Item number 70.
There is also no delay.
No delays. That is
well
disposed of.
Page 15 is the impugned order. That during pendency of criminal case, direction has been given to promotion. That matters. Similar matters are coming on 28th.
28th. All right. Notice returnable 28th. Stay of the impugned order.
Item 71.
May I please, Your Lords? 17 days delay, my Lord. The Lordship,
Delay is condoned. Yes.
my Lordship kindly see the last order dated 26/7/2022.
In 71, my lord, your lordship has directed me to file an counter. Lordship, grant me some more time, I can.
My Lord, Delhi Uses employee, my Lord, initially appointed Delhi Uses employee. I filed representation claiming, my Lord, regulation of service, and that was not considered. I filed original application before the learned tribunal. Learned tribunal directed to consider in accordance with the law, keeping the judgment of Umadeve and others, ML Kesori. They regularized me, but in the regulation order, inadvertently it is mentioned that regulation in terms of 2013 GA Department resolution. Similarly, situated complaints already been regularized. The sub-collector, who is not
the time for counter.
My Lord, stay, my Lord, other. I filed stay, my Lord, on the basis of impugned judgment.
There is an interim order, your lordship, that interim order is there. And we have allowed him to continue on
that is your assurance.
My lord's order 26/7/2000.
Yeah, that the petitioner would be engaged on daily wage basis.
Yes, my regular, I was appointed on the regular basis. After completion of 13 years of service in a sanction post, in terms of Umadevi and ML Kesori.
No, but what has happened? You're still working, no?
Working, yes. But in view of the judgment of the Honorable Single Judge, my Lord,
so you're losing monetarily. You're getting daily wages.
My Lord, I'm working since 2015.
I know, sir, but the final relief can't be granted at the interim stage. So, say consequently, respondent Seatson is granted final opportunity of filing reply within 8 weeks, rejoined up for the next 8th. Interim order to continue.
I may pardon my
21st December.
I may pardon item 69. The lordship fixed it to 1st December. This is 14th December. Similar matters is coming on 14th December.
14th December. All right. 69 is 14th December. All right.
Item number 72.
Well, even though the appellant was the party in the opposite party in the writ application, my lord, he was not given opportunity of hearing. And in absence of his counter, my lord, order has been passed, directing him to purchase the paddy crops against the tokens provided to the petitioner in the writ application. And respondent number 4. It is now impracticable, my lord, the lapse token period has already elapsed, and there is no funding of the government. And so therefore, he is unable to purchase the paddy crops, my lord. My lord, the OP number 4, my lord, the assistant registrar, my lord, after receiving the direction of this honorable court, my lord, has also issued a notice to purchase. But there is no fund, my lord, in the hands of the society to purchase. And your lordship will see 500 and some odd farmers were listed and were given tokens. But out of that, only 139 farmers would sell their paddy, and they couldn't. The other farmers, they could not sell, and the society could not purchase because of the lack of the funding and because of the not raising of the paddy which were purchased. That is now impracticable for him to purchase, my lord.
Only token is issued in my favor.
They don't have money, he says.
My lord, kindly have a glance. IA number 12097 of 2022. Assistant Registrar and Collector have already filed an interim application that the primary secretary of primary society who had issued the token to my client, he will purchase the paddy, my lord. Since token were issued, my lord, and now paddy is lying with the house of the
what to do, sir? They have no money.
Time. They are now taking false plea that fund is not available.
Why should they take a false plea, sir?
Yes,
no, my lord, your lordship may kindly come to page.
Assistant Registrar and the Collector also filed an interim application.
Resolution to that effect, my lord, I have filed. Token were issued only.
Now paddy will damage, my lord. Ultimately, if they will not purchase.
If government provides the money, my lord, there is no difficulty.
He is a poor farmer. Token were issued and they have also released to other farmers.
Only.
But my case is concerned, they are, my lord, taking that plea, that fund is not available.
Which are the other farmers to whom they've released? You have the names?
No, I have.
You file an affidavit. File an affidavit, you think they're giving to other farmers and not to you.
And I stand register and cooperative secretary, my lord. I stand register.
This contempt petition you have filed, sir.
My lord.
Contempt petition who has filed?
I have filed, my lord. Since
So
order.
don't proceed with it till we dispose of the writ appeal. Anyway, it's before us only. Notice, he accepts notice on behalf of respondent number 4. Mr. Mahanti accepts notice on behalf of respondents 1, 2, and 3. It will be open to the parties to file their respective affidavits before the next date. 5th January. That contempt case, you simply say list on 5th January.
Item 73.
Here, the impugned order is at Annexure 2, page 25, wherein since the appellant retired, the interim order was vacated. We are against that order. Annexure 2 at page 25, the interim order was in operation, but since the appellant retired, the interim order was vacated at the instance of the state. So that we have impugned. So it will affect the entire list would now be entered. So that's something which.
No, but since he is retired, what could be the some of the gradation list, right?
Without going into that, if my lords can say that it can be heard by the end of November.
All right. While not being inclined to interfere with the interim order, dated 9th September 2022, passed by the single judge, the court considers it appropriate to expedite the hearing of the main writ petition itself. It is accordingly accordingly a request is made to the single judge dispose of writ petition civil 3560/2020 as expeditiously as possible, and preferably within a period of 6 months. When is it next listed?
6 months can be end of November or end of this year. It's ready, Melody. In fact, it's ready for hearing. Similar matters are there, so a lot of people would be affected.
Right. When is this listed? Any idea when is this writ petition listed?
This because it's tagged to the writ appeal. So this.
Oh, I see. The writ petition shall now be listed for directions before the single judge on 1st November.
All
right.
We are grateful.
All right.
Supplementary list item 74.
My lord, let this be taken up with 85, my lord. This
All
is the maintainable.
All right.
Item number 75.
Please, your lordship, my lords. Lords, IA number 791 of 2009 for consideration. Lords, the appellant number 3 has filed an application for bail. Lords, he's aged about 74 right now.
Do you have instructions on?
No, my lord, we don't have instruction regarding the. He just wants bail on the ground of age, my lord. My humble submission is that this appellant number 3 is the father, and other accused 4 accused persons are his sons. Long-standing family dispute. The brutally assaulted 3 people, out of which 2 have succumbed to the injury. It's a double murder case. By the time of occurrence, this man was 67 years old. So, not that. The age cannot be considered because at that time he was the one who instigated this. At his instigation, his sons have brutally assaulted with all kinds of weapons, sharp edged.
How long has he been in custody, sir?
My lord, since 2015. For my lord's kind perusal, as per my lord's last direction, I filed a 2-page short note with a synopsis of the evidences, my lords. I filed it today, my lord.
There's an injured eyewitness.
Where is that? It's a triple murder.
Almost. Because the other person, third person, he survived. He was also
double
treated.
Murder anyway.
Double murder, yes. Double murder brutally, my lord. It's very gruesome, my lord. With all kinds of weapons, my lord.
You can expedite the hearing of the appeal, sir. Not inclined to grant it at this stage.
My respective submission, may place the evidence, Milords. So far as this appellant is concerned, there is nothing as such, Milords. Milords, may kindly have a glance to those 5 witnesses at least, Milords. PW1, who is the informant, Milords, his husband, one deceased Ramesh Naik, she has categorically stated that there was a lathi, Milords. The injuries sustained were of, Milords, sharp cutting weapons. There were 2 injuries that were found. The present appellant cannot be attributed to those injuries, Milords. But none of them have stated the present appellant to have assaulted in anyhow. But I've categorically.
No, it's a double murder.
No, that's not true, my lord, because if I take your lordship to the.
You're only referring to one deceased, sir.
Yeah.
Milords, there is another also, Milords, which is PW16's son, Milords. Milords, he has also stated that he has not implicated the present appellant, Milord, as to the assault on his son, Milords. I have categorically stated the second page. He is the injured eyewitnesses also, Milord. He has only stated that I have assaulted by way of body, but the 2 injuries that were sustained on the first deceased, that is informant PW1's husband, are of sharp cutting weapons, and I have categorically also stated the evidence of the doctor, Milord. 2 injuries highlighting.
To the second.
No, but PW's 5 and 6 both name you, sir.
No, even the injured eyewitness also names them specifically.
Unless they have all omnibussly stated to be a part.
No, para 5 says accused Udaya Naik and Padi. This is the present. We're holding 1 bamboo lathi each, and they were dealing blows with the lathi with certain force on different parts of the body of Ramesh Naik. Ramesh Naik was being assaulted with deadly weapons from all the sides. So it's a combined, well, at all 6 of them have taken part in the. And there are fractured wounds also, my lord. Scalp lacerated, skull bone fractured and deformed.
My lords, may see the evidence of PW19, the doctor, my lords.
Yes.
May I place it, my lords?
Yes.
There are 3 doctors which.
PW19 is.
19 refers to the deceased one, which is Ramesh Naik. But he has stated like this: there are external injuries, that is 1 vertical sharp cut wound on the left side of the occipital lobe of clear margin of size 5 into 3 inch behind the left ear towards the vertex, 1 vertical sharp wound on the left scapula of size so and so. On dissection, he found these, Milords, that is scalp lacerated, skull bone fractured, deformed, of the 2 injuries. Now, my lords, may turn to the next page as to the opinion of the death, my lords. Forming the above findings, the death was caused due to intracranial hemorrhage and shock, which was caused by sharp-edged, heavy cutting weapon. The nature of death is homicidal, and death was caused within 18 hours. Blood sample, so and so, my lords. Para number 4, my lords. Axe is a sharp-edged cutting weapon. On so and so, the Soro police had produced before me an axe and made a query if the injuries found on the dead body of the Ramesh Naik was possible. I examined the axe and went through my postmortem examination report. I have the following opinion: the injuries found on the dead body are possible by the weapon produced by me. My lords, may kindly mark the cross-examination by the defense. It is true that except the 2 sharp cut wounds, no other injuries associated with those cut wounds were noticed by me on the dead body. Para 5, my lords. The cut wounds found on the dead body were possible by single stroke each, my lords. If I, going to the prosecution story, my lords, I was holding a lathi. Someone has stated that it was a thenga. Nowhere, nobody has implicated me with regards to holding an axe or anything, my lords. My lords, and the injured eyewitness has categorically stated, my lords, there is no implication as against the present happened towards his own son, my lords.
IA 791 of 2019. This is a case of a double murder, and the injuries are grievous and severe, apart from being multiple. Full stop. Of the 5 eyewitnesses, at least 3 have named the present appellant. Number 3, who's applied for bail. Full stop. Although it is stated that the appellant 3 is over 70 years old and has spent 8 years, is it?
My lords, my lords.
8 years in
Since
prison.
2015.
The court is of the view that the better course would be to expedite the hearing of the appeal itself. The paper books be prepared within 8 weeks and be supplied to counsel for the parties. The application is disposed of. The main criminal appeal say paper books be prepared and supplied to the parties within 8 weeks. List for final hearing on 13th December.
Well, it's maybe someday in the month of January. Because my lords is packed up.
This is on 19th January. All right, 2023. All right.
Supplementary for admission item 76.
May I please, Your Lordship? May I be permitted to place this matter on behalf of Mr. Ramdas Achari? Your Lordship, we have received no such instructions from the petitioner regarding this matter.
All right. No instructions dismissed. All right.
Item 77.
None appears dismissed.
Item number 78.
May I please, my lord? I am on VC, my lord.
My lord, so far as today's instruction is concerned, I have filed the, Your Lordship, may kindly have a glance over the letter I have received from.
There are endless deaths.
Yes, my lord.
Deaths are continuous now.
Yes.
It is happening, and all of them, mostly all of them are electrocution.
Electrocution is a major cause.
Yes.
Your Lordship, I have filed an IN number 13345. In 2010, Ministry of Environment and Forest has given suggestions also for electrocution related death. I have an IN number 13345.
Well, on 17th, my lord, 2 elephants is dead, my lord, and due to poison, my lord. That is not for electrocution. On 7th October, my lord.
All right.
May I request that if this, because this is going on and on, let the people appear at least on VC and maybe on a Saturday, if that's okay. This needs to be addressed immediately, my lords. In fact, there have been several such orders, but they are not
non-stop. Actually, every other day there's some item.
And I think the court had come down heavily on them once, but thereafter, probably nothing seems to be working on the ground level.
Why is affidavits not being filed about what the Joint Task Force is doing?
Joint Task Force meeting was held on 19th October. We'll file the minutes of the meeting.
It stated the Joint Task Force held a meeting on 19th October. The convener of the Joint Task Force will file an affidavit placing on record the minutes of its deliberations and specific action points. Full stop. Although Mr. Mantil and AG has placed before the court a communication regarding the
current status.
Current status of the criminal cases. It is not clear what exact progress has been made in terms of arresting the accused in those cases where the suspect is still absconding. Also, in those cases where arrests have happened, the actual progress of the case beyond that stage is not clear. Full stop. The court would like who's the corresponding police?
This is wildlife. This correspondence.
No. On the side of the police, there must be somebody, right?
Yes. Crime Branch Department. Additional DG Crime Branch is.
Yeah, the additional DG Crime Branch to file a separate affidavit in this regard for the next date.
My lord, beside a pre, my lord.
We'll have to have it on a Saturday.
May I request that let them appear virtually, because that has an impact.
My lord, so far as filing of affidavit by additional DG is concerned, what I got instruction now, that joint task force has set up a committee, team of officers. They will file the necessary.
No,
JTF itself.
Let the officer file, because my lord, these lower officers,
They are officers, he is all officers, state government
concerned
officers.
person is
But
always
not the additional DG,
My lord,
because
this is the case where incessant
Highest ranking officer in the JTF.
My lord, I pray, my lord, it must be this honorable court must be examined, my lord.
Principal Chief Conservator of Forest Wildlife.
From the police.
Police department.
My lord,
one police officer, additional SP rank of Odisha Police. He is also one of the member of that joint task force committee.
The additional SP. Who's the additional SP rank, or who's his additional SP?
Okay.
Give us the name.
Jatin Kumar Panda.
He's additional SP.
Yes.
An affidavit be filed, then you say by Mr. Jatin Kumar Panda, additional SP, who's stated to be part of the task force, part of the JTF.
JTF.
My lord, I pray, my lord.
The members of the JTF will remain present virtually to answer the questions of the queries of the court on the next date.
My lord, I pray, my lord.
The difficult is this they're all holidays, 12th, 19th, and all of that. We'll have it on 3rd December. It's a Saturday.
We will submit the comprehensive action plan also on that.
Yeah. On which
My lord, may I
court
pray,
will be
my lords?
presented with a comprehensive action plan.
My lords, may I pray, my lords?
Yes, please.
3rd December is World Disabled Day. It will not be convenient for me if it be any other Saturday.
Next, any date next week. 10th December.
Last December. Any other.
Actually, Saturdays are problematic because
My lord may not post it in any Saturday because Friday it
My
can
lord,
be.
I pray for a short date, my lord. A short date may be given, my lord. And my lord, beside I pray, my lord. Am I audible, my lord?
Yes.
My lord, I pray this honorable court must examine who are the person included in the joint task force, my lord. This wildlife experts,
That
my
is
lord.
already filed.
No, that has to be examined, my lord. Who are these persons, my lord? Persons
So we
those
can
who
have
are
it at 2 p.m. on a Friday then.
My lord, let it be on a Friday.
Or
at 2 p.m.
So we can have it on 11th November at 2 p.m.
My lord.
All right. 11th November at 2 p.m.
Maybe in December.
No, they can't. My lord, the reason why we are pressing for a shorter date is that at the ground level, nothing is happening.
Right.
So let it be on 11th November.
All right.
My lords, prior to that, prior to the VC meeting with the task force members, I think your lordship had suggested that we given some suggestions to the committee to accordingly provide the spectrum of the inquiries of the spectrum of the work. So we are not aware as to what exactly the task force has been given to talk about. So to meet the task force
Let
without
them appear, we'll get to know that.
We will give that answer that in our affidavit.
All right.
My lord, I would like to bring to the knowledge of the honorable court, my lord, persons those who are taking contracts from the forest department, they are being included in the joint task force, my lord.
All right.
As the wildlife expert, my lord. That must be examined, my lord.
All right.
Item 79.
Lord, item 79 appearing for the respondent number 1 through VC, my lord.
May I please? May I please? I am giving a written note, my lord, a date chart, short date chart for my lordship's convenience. Here in the entire case, my lord, only one pertinent question of law is involved, my lord. That is, whether a lady after being married will remain under the status of her, my lord, her father, or she will continue the status of her husband. That is the only question decided to in this writ appeal, my lord. The notification for a particular center, Anganwadi worker, was issued on 11/2/2015. And the respondent herein, that is respondent number 1. She being married.
The only question is, where are you permanently resident? That's the only question.
My lord, she permanently reside at her husband's place.
Which is where?
That lordship will find in the in the counter of the state, that is filed in WPC number 2672.
Where does she stay?
In Kendrapada, my lord.
No. Kendrapada is a whole district, sir. The center must be a very specific thing, sir.
Center, he is, my lord, at Kochahudi Anganwadi Center under Jajpur district, that is nearer to Jajpur Road.
Is she not supposed to be a resident of that place?
No, she was a resident of that place prior to her marriage. And after marriage, she had gone to her husband's place. 2 children are there. They are studying there. And when the advertisement came up for appointment of Anganwadi worker, she applied by getting a residence certificate from her father's place. She applied for the said post.
How will that be valid, sir? She can be appointed only where she is a permanent resident.
Lordship may kindly peruse. Lordship may kindly peruse the order passed herein by the learned ADM. The ADM has taken note of that fact, and under Annex 3, page 21. She has been decision case in the year 2015. Basing on that score, that she has submitted a residence certificate of her father's place.
Should I explain now, Mal?
Yes.
Sorry.
Yes, please.
Lord, if Mr. Misra has completed, let me tell you, Lordship, what is the case about. This present petitioner, on the basis of her residential status, was initially appointed as a helper for the same center, Anganwadi helper, on the basis of her residential status, much prior to the advertisement, was continuing as a helper. So while continuing as a helper with same residential status, advertisement was published for worker in the year 2014. So with the same residential status, she applied for that and she is upgraded as an Anganwadi worker. The present appellant challenged and sought for a direction from this honorable court for her engagement in my place. Matter was relegated back to the sub-collector. Now, sub-collector considered the entire matter on her appeal and passed an order that my engagement selection is valid. Pursuant to the sub-collector's order, engagement order dated 28th of January 2015 was issued in my favor. I am continuing as such, my lord. So, suppressing that sub-collector's order, she again filed a writ petition before this honorable court on a subsequent writ petition, got an order to file appeal before the ADM. Now, before the ADM, sub-collector's order was suppressed. Now, ADM, not for the take note of the facts, passed a second order. Now, that ADM's order was challenged before this honorable court. If your lordship would kindly see the judgment passed by the honorable single judge, I'll only take your lordship to the relevant paragraphs. Internal page 11, running page 55, your lordship may kindly turn. The honorable single judge has dealt with the aspect of suppression of fact. The present appellant suppressed the sub-collector's order all through. Kindly see. Sub-collector's order forming basis of my appointment was never challenged. Now, second round of litigation without disclosing the facts were initiated before the ADM. Secondly, my lord, even on the ground of residential issue, the lordship sees, my lord, this honorable court has taken, the single judge has clarified the matter. The lordship sees internal page 15. Based on 2 affidavits, ADM has passed an order. My residential status was never challenged. My certificate was never challenged. I was continuing as a helper over the same center on same residential status. Even after my marriage, my client continues over the same residence plot. He continues to stay there because he is engaged there. Only she is working there. Kindly see, my lord, page 15. Internal page 15 of the judgment passed by the Honorable Single Judge. The Honorable Single Judge categorically on fact held that I am a resident of Anganwadi Center area. Should I place it, man?
Yes.
But it starts from page 58. It is not in dispute that petitioner before solemnization of her marriage was working as an Anganwadi helper for the center in question, which also carries the same eligibility condition of residing in the center area. But in the year 2010, after solemnization of marriage, the dispute has been raised that after solemnization of her marriage, she will said to be residing in her in-laws' house. But the fact herein is that petitioner has got the residential certificate on the basis of declaration given under the affidavits dated 6/2/2010 and 22/2/2014, showing her permanent resident of village Sobara, while showing the in-laws house of Ahmadpur of Kendrapara district, and competent authority has conducted an inquiry and found that petitioner, even after solemnization of her marriage, is residing in the center area, as would be evident from the report dated 20th of January 2015. The competent authority, on the basis of the report of the revenue inspector, has issued residential certificate to her permanent resident of village Sobara, on the basis of which she has been engaged on Anganwadi work. Kindly see. So this part of the Honorable Single Judge's order, kindly see, Lord, and the Honorable Single Judge has taken care of thereafter. ADM Jaspur ought to have taken into consideration the fact so long as residence certificate is in existence, have not been annulled and cancelled by any competent authority or court of law, the same is to be given reliance. And merely on the basis of two affidavit, residential certificate issued by competent authority on the statutory provision cannot be said to be lost its force. Sub-Collector Jaspur, after taking into consideration this aspect of the matter, and when found that she is residing in the center area, has also found the petitioner to be more meritorious in comparison to that of the present OP number 5. The appellant now has directed CDPO Korei to finalize the selection procedure and select in accordance with merit of one or other candidates in view thereof. The petitioner has been selected by engagement order dated 28th of January 2015, and the said order has never been brought to the notice in Jaspur. So all about suppression of material fact, that, and if your lordship would...
He has suppressed the thing. He has suppressed by swearing false affidavit before the concerned authority in getting the residential certificate, my lord. On 12/2/2014, if my lordship will look into the writ petition, that is 11794 of 2015, writ petition annexure 8, lordship may kindly peruse that a affidavit shown by the respondent number 1 is available to my lordship. That is a false affidavit by the respondent number 1. She was married since 2004. And both the birth certificates were exhibited before the learned ADM. And now she is claiming that she is staying at her father's place without being a destitute lady or divorced or anything else.
But my learned friends would not make such a submission in view of amendment in 2005 Hindu Succession Act. Lord, there is no bar in after marriage to continue.
Correct. Absolutely.
But my lord, in the notification, there is a stipulation that a person should be a permanent resident of that particular service area. After her marriage in 2004, the notification was issued in 2014. And after 10 years, she has filed a false affidavit stating that she was continuing in the post of Anganwadi helper. That's how she will continue in the same residence certificate.
All right, we'll pass the order. We're not inclined to interfere. The appeal is dismissed. We'll pass the detailed order.
Item number 80.
My lord, in this conducting counsel very seriously ill today, so...
All right, counsel, the appellant stated ill. This on 6th February.
Item number 81.
Item 81, the lordship has issued notice. None has appeared.
No, in the second case, I am appearing for the respondent, my lord. 2 weeks time may be allowed to file a
As the lordship has said, the second case, the first that the matter has been disposed of. Page 41, my lordship, page 41.
First day disposal.
Yes.
If you agree, we can expedite petition. You can go back. First day it has been disposed of.
All the three matters are same, but in two other matters, none has appeared for that. But in that case, only date is to be changed. Similar matters.
Let it go back, sir. November.
Yeah.
Same order in all three.
Only dates, some more time be given for filing count.
4 weeks for counters, that more than enough. So that date on which to be on that.
That was the
26th November. We say we listed on 19th December. No, I think 9th January.
Item number 82.
Yes, I am appearing for the appellant, my lords.
No, they have served a copy of affidavit today. I dispute that. I will file an objection to the affidavit.
I have
filed by clerk.
I am explaining the affidavit. Here the question is, my lords, resignation of the husband of the petitioner as a partner.
Can the advocate clerks file your lordship has said that
Today my clients could not come. I have filed the affidavit. Let him file. I will file the affidavit in the meantime through my officer. This affidavit was submitted to the IOCL, where said any person.
Last time you wanted to file a detailed note, no?
I have prepared the note. I have prepared the note at date. But today he served a copy of the additional affidavit which has been shown by the clerk, advocate clerk.
Because, my lords, the company sent the copy to me by mail. I have asked.
Let him file a proper affidavit at least.
I will file.
All right, let him file a proper affidavit. You say Mr. Das, senior counsel appearing for the appellant, states that he will be filing an additional bit of the appellant within 1 week. Mr. Pal says his note will be ready and will be filed before the next date. December 20th.
Can it be in the month of November?
Yes.
Item 83.
May I please your lordship, my lord? The application was filed under section 24 CPC for transfer of the matrimonial suit, my lord, from Jharsuguda to Sambalpur. And the order is at page 31, my lord.
In this case, my lord, I have already appeared on the 27th July, but my name does not reflect in the cause list, my lord.
All right. The order dated 27th July. Oh, in the cause list, is it?
In the cause list.
Oh,
no, it was listed on 27th July, my lord, because there is some interim order. Order number 2, my lord, your lordship may see.
All right. The name of Mr. Guru be reflected for the respondent in the cause list. Yes.
And there is some interim order, my lord, that should be extended.
Yeah. List on 6th February, interim order continue.
Raise the question of maintainability here, my lord.
Yeah. Mr. Guru raises the question of maintainability. This will be addressed by the counsel for the appellant on the next date.
My lord.
All right.
Item number 84.
On item 18.4, learning senior counsel Mr. Yashwant Das appearing for the appellant is not well, my lord. I pray for a short
Stated Mr. Das and senior counsel.
This matter, Mr. Das telephoned me, this is a very close friend of mine. Some medical issue, he said 1 week time. Next week is a MSME matter, Lordship. No, the last order Lordship passed. So kindly fix it next week, any date.
All right. 15 November. All right. List on 15 November.
Interim order to continue.
Interim order to continue. Grateful.
Item number 85.
This is that maintainability thing.
Yes, Params. I'll first of all address your lordship on the maintainability part before I go to the merits of the case.
Who's the other side now?
My lord, I am appearing for a project.
You're ready to argue because he's going to be citing.
My lord, I am otherwise ready, but if a maintainability question will be taken up, my lord, first decide, then I will address on merit, my lord.
Okay. You're not raising issue of maintainability then?
I am not aware about a question of maintainability.
Okay then.
Yes, my lord. I am raised the question of maintainability because writ appeal is not maintainable. But
no.
Yes, my lord.
If you say you're not raising that objection, then he'll go on the merits.
No, my lord. I am raising the such objection. That is my objection. Really, is not maintainable.
All right. Are you ready with the arguments? Because
my lord may play some other day.
All right. The interim order will continue then.
There is no interim order operating in my favor. So your lordship may grant me an interim order and any day convenient, your lordship.
Counsel for the parties want to address the issue of maintainability. List on 9th November 2022. The further proceedings in the suit shall be deferred till further orders of this court.
That is election miss case 18 of 22.
That is election miss case 18 of 22.
22 in Civil Judge Senior Division, Jajpur.
Yeah, in the court of the Civil Judge Senior Division, Jajpur. Shall be deferred till the next date.
Pardon you,
till further orders.
74. Also similar question is involved. 74.
So there again, notice subject to satisfying the court on maintainability, and
Yes,
then list on the same date, and further proceedings in.
That is, my lord. Election miscase. Election miscase number 10 of 2022.
10 of 22.
Pending before the election tribunal comes Civil Judge Jajpur.
Okay. Shall be deferred till the next order.
In this case, my lord, I am for the respondent. I have not filed any counter on my mention. It has come, my lord. And if my land senior is ready for a hearing of the case, my lord, for all time to come, it can be closed. Otherwise, my application seeking for stay of other proceeding of the criminal case, election case. If you are ready, then let my lord.
Item number 86.
Make please, man. Now, what was assailed before the Honorable Single Judge was this, my lords. Cryptic order was passed by the election tribunal condoning the delay. No reasons were given. So 4-line order, heard, admit, delay, condone, and notice issued. After the appearance of it was done under 31. The satisfaction was not recorded while condoning the delay. After the notice was issued, then my learned friend's client appeared before the tribunal. On appearance, he raises the issue of condonation, and how could such a delay be condoned? Delay was only of 17 days. How could it be condoned by a cryptic order? So therefore, he challenges the matter, saying that delay could not have been condoned without hearing me and all that. He raises the entire issue. He files an application under Order 7, Rule 11. The application under Order 7, Rule 11 was heard in extensio. His entire point in Order 7, Rule 11 was that delay could not have been condoned. The election tribunal relies on section 31. I'll just place that section before your lordship. Section 31 of the Gram Panchayat Act. 1. The petition shall be presented on one or four or more of the grounds specified in the section 39 before the civil judge junior division having jurisdiction over the place at which the office of the Gram Sasan is situated, together with a deposit of such amount, then managed straight away to the proviso. Second proviso, provided further that if the petitioner satisfies the civil judge that sufficient cause existed for failure to present the petition within the period aforesaid, the civil judge junior division may in his discretion condone such failure. So at that stage, my lords, this section would logically mean it is between the court and the election petitioner of the election petition, my lords. Then, my lords, he files Order 7, Rule 11. Order 7, Rule 11, my lords, is that page 39.
This impugned order, the single judge remands it to the election tribunal to again decide delay.
Yes.
Trial. But that the specific question that your lordship posed, the specific question that your lordship posed in this case was this, my lords, that whether that delay was addressed at all by the other side was at all, the issue was at all addressed by the court or not in presence of the other side. My submission was this, my lords. That your lordship finds at page 42. The order arises out of a petition filed by the opposite parties 31 under Order 7, Rule 11, read with section 151 of the CPC, praying to reject the election petition. The assertion of opposite party number 3 is that as per law, the election petition ought to have been filed within 15 days of declaration of the election of the Gram Panchayat. In the present case, the election was declared on 28/2/2022, but the election petition is filed on 4/4/2022, which is beyond the limitation and barred by law. Hence, as per Order 7, Rule 11D, the election petition is liable to be rejected where the case appears from the statement of the election petition to be barred by the law of limitation. As per law, the petitioner should prove the cause of his delay for non-filing of the petition in time by adducing evidence to satisfy the court to condone the delay. But in the present case, the condonation of delay. As such, the election petition is not admitted. Hence, the same is liable to be barred by time, and accordingly, the election petition is liable to be rejected. Further, the election petition does not disclose any cause of action and is liable to be rejected. The allegations in the election petition are totally false and baseless, and the election petition does not disclose the material facts with regard to the case. On the other hand, the election petition in its counter contains that the allegations in the petition are false and not maintainable. It is categorically pleaded in the election petition that as per rules, the publication of the result was made on 2/3/2022 and the petition ought to have been within 15 days on or before 17/3/2022. But as the election petitioner fell sick, this is the part. Having suffered from E fever and P neuritis since 10/3/2022 and was under treatment in CHC Bella Guntia as a patient-wide OPD registration number 8340, dated 10/3/2022 till 17/3/2022, and his treating doctor advised him to take bed rest for 2 weeks from 17/3/2022, that is on 31/3/2022, and since 1/4/2022 to 3/4/2022, the court was closed on account of holiday. The election petition was filed on 4/4/2022 after reopening of the court. As such, while disposing of a separate petition filed by the petitioner, this court, after examining the documents, this was his main allegation. After examining the documents filed by the petitioner in support of his illness, was satisfied that there exists sufficient cause which prevented the petitioner to file the election petition within 15 days. So such petition of the election petitioner was allowed by this court in condoning the delay and allowed the petition under the provisions to section 31(1) of the Orissa Gram Panchayat Act 64 of the petition by invoking the discretion. Heard both parties at length, the OP3 has claimed that the election petition is barred by limitation. It does not disclose any cause of action. It should be rejected as per Order 7, Rule 11. As far as the issue relating to the point of limitation, this is the court's finding. After this is what was pleaded. He's saying he was not heard, he was heard. Limitation is concerned, section 31(1) of the Orissa Gram Panchayat Act enshrines that the petition shall be presented on one or more of the grounds specified in section 39 before the Munsif having jurisdiction within 15 days after publication of the result of election, and the proviso to it states that if the petitioner satisfies the Munsif that sufficient cause existed for failure to present the petitioner within the aforesaid period, the Munsif may in his discretion condone such failure. Accordingly, this is the finding. After going through the medical certificate of the election petitioner, along with his ticket for outdoor patients produced by the election petitioner, and on being satisfied that there was sufficient cause for non-filing of the election petition within the statutory period of 15 days, this court had allowed the petition under section 31(1) of the Orissa Gram Panchayat Act, read with section 151 of the CPC. The same has been reflected in the order sheet on 5/4/2022. Though it has not been specifically mentioned in the order, that delay has been condoned, allowing the prayer of the election petition 31(1) of the Gram Panchayat Act with section 151 of the CPC tantamounts to condonation of delay. During the course of argument, rightly pointed out by him, I am of the opinion that it's a mixed question of fact and law and can be determined only at the time of trial. So this manner, the issue is not that he was not heard at all. He was heard extensively. Then he comes to this honorable court at the first round and he challenges this very order. And challenges the fact that the delay was condoned without hearing him. So on technical grounds, it was dismissed. The matter was dismissed, saying that there was some wrong filing. At that point of time, he doesn't challenge the first order which condones the delay. Second time, on the second round, he comes with two petitions. First petition, my lords, he challenges that order condoning delay. And the second petition he files.
This order.
This order. Both were taken up together. The honorable court heard the other one, remands it back. And this one, when submission, my lords, probably honorable court was swayed by the fact that it was a cryptic order and it was not heard. Then, my lords, the attention of the court was drawn to the fact that this order was there, where he has been heard and details and documents were produced and the court was prima facie satisfied. The rest of it can be decided at the time of hearing.
But tell me one thing, the same thing, no? 711 is challenged in a writ petition before the single judge, against which you file a writ appeal.
My lords?
711 order is challenged.
No, he has withdrawn that 711. 711 was withdrawn.
Actually, it's not correct, my lord.
No,
first it was withdrawn. Then that is the mistake you have committed in the first occasion.
711
in my case, all you will do.
That writ petition was withdrawn.
With the liberty to file a fresh because there are some defects.
But when you filed a fresh, did you challenge the 711?
711, yes, my lord. I filed. Both the cases were taken up together. Common judgment, judgment was passed. He has challenged one. Other one, no order was passed because court held. Since I am reminding matter to the initial stage, he must hear the first issue of limitation, then only proceed with the trial.
No. What happened to the 711 order?
711, no order was passed. Court observed that no order is required to be passed in view of the order. This writ petition.
That may not have been a correct approach.
But either way, it's an interlocutory order in an election petition. So dealt with by the single judge under 226 or 227?
226.
227.
That is what was probably arresting your lordship's attention when your lordship posed that question.
Correct.
Our High Court has decided. Our High Court has decided already, has held that only 226 powers can be exercised
But what does the impugned order, how does it hurt you really? How does it hurt you?
The trial is held up. Tomorrow the plaintiff is to be examined. Tomorrow the plaintiff is to depose. At this stage, he wants that.
We'll make it time bound.
No, I am interested that the trial should continue. The plaintiff before the trial court, I am challenging his petition. He is the candidate who has succeeded.
Correct. You are the plaintiff.
My lords.
Ah.
So I am to depose tomorrow, 21st.
No. That you're only to depose. I'm saying suppose we make this decision on the invitation time bound, saying that it should be decided within 15 days.
There already, Honorable Single Judge has taken note of. It is only given 15 days. Both the parties allowed 15 days to complete their course of argument. And ultimately, civil court has to take a decision within 15 days.
What will happen? This opens up a parallel window for, again, that order will be challenged here. And in the entire process, the entire intention of the statute is lost. The trial gets held up interminably. Every time they get. That is the reason. In another case, your lordships have said that it's a hands-off policy. Second case, by the division bench of this court, your lordships have held division bench.
You show us also that maintainability, that other judgment.
Yes.
At 226, you said it's an exercise in 226.
Yes, this. Paragraph 2, last part. Paragraph 2, last part. On a perusal of the various sections, it is clear that appeal lies only against final orders passed under subsection 1 and 2, and no appeal lies against interlocutory orders. Those very subsections make the provision for awarding of costs at the discretion of the monarch. The first proviso to the subsection 3 makes the position further clear that the appeal is to lie against any order made under section 38. This section makes no provision for passing of interlocutory orders. It merely conceives of final orders, either of dismissal or of allowing the election petition. We are therefore satisfied that there is no substance in the preliminary objection, no appeal lies to a district judge, and only remedy is by an application under 226 of the Constitution. So whatever power has been exercised, my most humble and respectful submission before your lordship is this: there is a power exercised under 226. So my writ appeal would lie. And my lords, having addressed on that point, my lords, the second point is this, my lords. There's another judgment, division bench of this court, which has decided, my lords. Maganlal. Maganlal Behra. I'll pass on the judgment. In the meantime, I'll just place it. If your lordship permits me, I'll place it.
On reference.
This is 2005 supplementary OLR 668 page. Page 3, Manglal Charan Behra versus Banmali. This judgment was also cited before the Honorable Singh. This has been taken note of in the order. Your lordship will find that. Page 83, my lords. Page 83 of my brief, my lords. Since the application for condonation of delay is decided ex parte, there is no possibility of objection the party likely to be affected, and disputedly the petition has so many pleas. So and so on. And then Sri Mangalal Charan Behera, this court finds paragraph 1 therein remains as follows. The petition in this writ petition has sought for quashing of the order under Annexure 1 for directing disposal of the election miscase number 1 of 2003 pending before the Civil Judge Junior Division Balasar within a stipulated period. The petitioner was the returned candidate being elected as Sarpanch of Markona Gram Panchayat situated under Simulia block in district of Balasar. The opposite party number 1 filed election miscase number 1 of 2003 before the Civil Judge Junior Division Balasar under the provisions of the Orissa Gram Panchayat Act. The admitted case of the parties is that the election was held on 19/2/2002 and the results were declared on 21/2/2002. The election petition was filed by opposite party number 4 on 15/4/2003 along with application under section 5 of the Indian Limitation Act. It appears that after filing of the election petition along with the application for condonation of delay, the learned Civil Judge Junior Division Balasar condoned the delay by exercising power under the second.
Actually, all this is also adding to the delay. See, your purpose is not going to get served by going on challenging this. Now, against this, again, there'll be a further challenge. I don't know. There'll be an endless. See, this becomes counterproductive even from your point of view.
No, my point is this, my lords. My point is
might as well get that delay properly adjudicated after hearing him. That's what the learned single judge says. We make it time bound. He had already made it time bound within 15 days from 10th October. Because of the state granted by this court, it's got postponed.
Well, the point is he has already been heard under Order 7, Rule 11.
I'm saying by trying because
it's a full-blown hearing.
He had fixed a date of 14 December, which means your examination would not commence till all that is over.
No, my examination will commence tomorrow.
No, that's over.
My examination will commence tomorrow. Because
unless we say the delay is condoned, unless we decide, delay is to anyway be decided. It's still.
My lordship already held in that decision.
The order condoning delay has been set aside by the single judge. The matter has been remanded to the election tribunal for a fresh decision on delay. So till the order of the single judge is set aside, the question of your examination commencing tomorrow does not arise.
The examination can be deferred, your lordship can hear me.
No, but I'm saying that this whole thing therefore is counterproductive.
No,
why are you avoiding a proper hearing? Since anyway you have a good ground for delay, it's only a question of
what happens here. Ballots. What happens is here. What happens is a new ballots and avenue has been opened.
Not really.
When your lordships are really
anyway that avenue can't be shut. Anyway, he has a right to challenge under 226. You yourself say 226 is available.
My lords.
That can't be shut out anyway.
No, 226. No, there your lordships have said, while not disputing the power of your lordships under 226, your lordships have said that since the Act mandates speedy disposal, interim orders
can make a time bound and
interim orders can also be done. Limitation can also be raised by way of an issue framed and can
is your reply ready?
Yes, I have already filed. Pursuant to direction of Honorable Single Judge, I have
already filed.
Yes, on 11th I filed. On the date
we'll now list it before that election tribunal on 1st November and say that he should decide it by 11th November. So at least that will be time bound. You say the court notes that in the impugned order, the learned single judge has also already made the proceedings concerning condonation of delay in the filing of the election petition.
Issues have already been framed.
Yeah, time bound by mandating that the issue should be decided within phase from 10th October 2022. Paragraph. However, by virtue of the stay order granted by this court in the present appeal on 10th October 2022, the said proceedings has not progressed further. Paragraph. Having heard Mr. Suvir Palak, learned counsel, senior counsel appearing for the appellant, and Mr.
Lordship doesn't misunderstand.
All right.
He will be deciding the issue by virtue of your lordship's remand. Now, he has already framed the issue on limitation as the first issue.
Anyway, he'll only decide that first issue. He'll only be deciding that first issue.
Again, that will be open for...
It can't be helped. That can't be helped at all.
Elected representative.
You see, and you heard, and Mr. K.K. Mishra and counsel appearing for the respondent number 1. This court, without interfering with the impugned order of the learned single judge, further directs us under 1, since Mr. Mishra states that his client has already filed a reply before the election tribunal on the issue of delay. The election petition will be listed before the election tribunal. You can have it on 26th itself. On 26th October 2022, on which date the issue of limitation will be taken up and arguments advanced and concluded positively by 28th October.
2 days not possible, Milord, because the doctor has played the mischief. Who has issued the we claim that
he wants to examine the doctor.
Yeah, exactly. Unless he is examined,
concluded by
15 days. Your Lordship kindly grant me. Within that, I will complete.
No.
I undertake, Milord. I give assurance, Your Lordship.
By
4th November.
You have 7 clear days.
Only 3 days more. 7. Your Lordship.
Now there is an examination of the doctor also here.
I am an elected candidate.
Parallel trial.
No, let it be done by 4th November. It's only on the issue of one doctor, one witness. And concluded by 4th November. The verdict of the election tribunal on issue number 1 pertaining to limitation be delivered by 14th November 2022. The writ appeal is disposed of in the above terms. Copy of this order to the concerned court forthwith.
Urgent copy of your Lordship.
Urgent copy.
One password. Supplementary list password matter item number 9.
Yes, my lord. That due to
this matter,
nothing stamp report has yet been made by the office. First of all, and second part, the already the Hoklatrama already filed. The office has pointed out due to non-filing of Hoklatrama. Hoklatrama already filed in its original CR LMP.
Hoklatrama filed?
Already filed in the original CR LMP. It is the REIT appeal.
For appeal, you have to file a Hoklatrama, sir.
Sir, Hoklatrama no need of. If court interested, then all right. I'm just going to file the Hoklatrama.
File it to the registry, sir.
Yes, sir.
Counsel states that he will file the Hoklatrama.
And direct office to remove the defects
within a week. Yeah, and cure all within a week. What is the matter about? Enforcing an order dated 9/6/97.
No, the order is 145 subsection 6. That order was now still in force.
Sorry?
Order now still in force. That order has not yet been complied by the.
See, there's a time limit within which you come for compliance, sir.
No, it is a coterminous nature. I will satisfy. I would satisfy before the court whether the order is just it is a coterminous nature until subject to result of the civil court. Civil court, unless the effective decree has been passed, that order will continue. Supreme Court, 1960 Supreme Court. It's clear decision. Subsection 6 order, 145 order was passed by the competent court. Means executive magistrate of Venice. In CMC 403 of 95, which was got decided on 1997 in favor of the petitioner.
How is this enforcement? I don't understand. CRLMP. Is the subject matter still alive? Because what happened in 2016, you have got no order in your favor so far.
Your Lordship.
You were complaining of somebody interfering in your possession in 2016.
No. To whom direction was made, they are not implementing the order.
What are they supposed to do? By implementing means what are they supposed to do?
Subsection 6 of 145 law.
No. What are they supposed to do? According to you, what are they supposed to do which they have not done?
I have the competent court means the executive magistrate has directed the IIC station officer of Khandwari police station to implement the order of.
Implement means what, sir? What is he supposed to do? To enforce, to implement? What is he supposed to do?
Some miscreants are frequently coming to the spot, coming to the land and creating this or that.
Sir, 2016 you made this complaint.
No, you're so now frequently now continuing.
There's nothing to show. You file a fresh CRLMP then if it is continuing.
No, I have already filed.
No, there are intervening facts, sir. There's so many facts will change.
No, your lordship, now the impugned order before this court, impugned order passed by the single bench. Now, I would like to first of all the Oklatnama receive the Oklatnama and give a least chance to the petitioner to put forth before this court. Sir.
No. It's okay. You say a perusal of the impugned order reveals that what the petitioner was, the appellant was seeking enforcement to us of was an order dated 9 June 1997, passed by the Executive Magistrate Bhubaneswar in Criminal 409(3)/95 under Section 144 CRPC. Paragraph. The learned single judge noted that the subsequent order purportedly passed by the executive magistrate passed by the additional deputy commissioner of police come executive magistrate Bhubaneswar has also been challenged by the petitioner in a revision petition before the Sessions Judge Bhubaneswar. The writ petition was accordingly dismissed on the ground of maintainability. Paragraph. Having heard learned counsel for the appellant, the court finds that the real grievance he has is about some miscreants disturbing his possession. Full stop. If that happened way back in 2016, there is nothing placed on record to indicate what has happened in the meanwhile. Full stop. Counsel for the appellant then submits that the same problem is continuing. Full stop. If it is, it will be open to the appellant to seek other appropriate remedies in separate proceedings, in separate substantive proceedings in accordance with law. The writ appeal is accordingly dismissed.
Your lordship is what the lordship does want to satisfy about what is the present cause of action. Your lordship want whether there is present cause of action or not.
And you can always have a substantive petition on basis of fresh facts.
No, your lordship is continuing.
All these matters are not supposed to be
continuing. Their action.
Then you have to file a fresh affidavit. You have to file a substantive petition.
Already filed.
And you have to name those people. They have to be given a chance of appearing, of explaining their case. You can't simply have vague petitions like this. It's not capable of being enforced.
Your lordship, kindly see what happened here.
So we are not offering free legal advice here.
No, your lordship. The order itself is still in force or not? That order passed by the executive magistrate.
We have not said anything, sir. If A, B, C are so-called miscreants who are disturbing a position, you have to make them parties.
Yes.
They have to be given a chance.
This should not be made as a...
I see. Because this is new law. Anyway, we are not here discussing all this. Follow the next matter.
Item 87.
All right.
Your lordship...
all right, sir. All right. Thank you.
For hearing item 87.
May I please, Lordship?
Yes, please.
This case, my lord.
You had a busy day, Mr. Ragada.
My lord. Here is case, my lord. The earlier occasion, my lord, I have somehow argued sometimes, my lord. But in fact, my lord, the conviction under section 302, 34 IPC and section 324 IPC for one of the injured is my lord. In this case, my lord, the fact of the case like this, my lord, perhaps your lordship, I want to press remember, my lord. The IO received a telephonic message that 2 persons died in a village, my lord. Thereafter, I reached the spot after entering the stationary entry. And at this spot, my lord, Pidol 1, who the son of one of the deceased, my lord, he lodged an information before the police, stating therein that he got information from Pidol 11, who claims to be an eyewitness to occurrence, my lord, front of the informant, my lord, that the accused persons and 2 other, my lord, all total 5 accused persons, all of them assaulted the deceased persons. That is the case, my lord. Thereafter, the IO receiving the FIR sent the same to the PS for registration of the case. After the registration of the case, my lord, the IO started investigation, my lord. But in this case, my lord, I want to draw your lordship's kind attention to the FIR, my lord. As 28, my lord, and in the FIR, my lord, there are 2 FIRs, my lord. As page 28, the Pidol 1 lodged information, my lord.
Right.
On the formal FIR, column number C, my lord. Information received dated 28/8/2000. Time 8:15 AM at spot. And thereafter, that has been, my lord, though the time was mentioned
at PS,
my lord, at PS, that, my lord,
it's been scored out.
Scored out, my lord. That's the reason, my lord. Another thing, my lord, in the top, my lord, that have been sent to the magistrate. Magistrate received, SDGM Baragarh received on 22/8/2000, my lord. That is, my lord, the one of the aspect, my lord. Though the FIR lodged on 28/8/2000, my lord, but that has been received
2 days late.
2 days late, my lord. That is one thing, my lord. First, my lord, the formal FIR, my lord. At page 34, my lord, another FIR, my lord, that has been lodged by the 2 of the accused persons, my lord. The IO stated that when he returned back from the spot, my lord, at the police station, the IO found 2 of the accused persons sitting at the PS, my lord. Thereafter, they lodged. That is the case, my lord. But 313 statement, my lord, the informant, Sarathi Mahapatra, denied that. She stated that in 313 statement that I have not lodged any information, my lord. This, my lord, the FIR, my lord, Bharan PS case number 50/2000, my lord, that has been created by the IO in order to entangle the petitioners, my lord. As because the IO in his evidence stated that though the FIR lodged, that FIR, my lord, final report was submitted, my lord, though the one of the accused, Sarathi Mahapatra, signed the FIR and the entire contention of the FIR, my lord, the handwriting of that person, and the date and the name only, my lord, signature there, my lord. And Sarathi Mahapatra 313 statement stated that after he has not lodged any information, there is no such case, my lord. That is creates doubt, as because, my lord, in order to implicate these petitioners, my lord, this FIR manipulated one, and that has been inserted in this case, as because that is when the first information received, my lord, station agent first received, my lord, the person who telephoned to the PS, my lord, the IO no point of time ascertained who that person who telephoned the police station, my lord, and that my lord, stationary entry also not available in this case, my lord. Though the first case, my lord, that I am reached at the police station after 2 days, my lord, before the match, my lord. Also, it is creates doubt, my lord. That happened, my lord. Another thing, my lord. On the other day, my lord, I submitted before lordship, my lord. There are 2 doctors, my lord. Though there are 8 to 7 injuries sustained by both the deceased persons, my lord. Specifically, the treating doctor stated in their evidence in chief that one of the disease cause of death due to asphyxia due to injury on the lungs. Another disease, there is a injury. The doctor, my lord, opined that the only injury on the heart, my lord. There are two injuries. There are multiple injuries there, my lord. There is the allegation that all the accused persons are attributed to two of the deceased persons, my lord. Relying that, my lord, one of the accused acquitted, another accused, though they have been acquitted, my lord, but during course after he expired, my lord. And so far these three accused persons, my lord, are concerned, both are belongs to one family. In the affair, my lord, the informant stated that on the previous day, on previous night, my lord, there is a quarrel between the one of the wife of deceased and the wife of one of the appellant, my lord, regarding, my lord, only rupees 42, my lord. And the wife of the accused, one of the accused, stated he will not pay 42 rupees, only pay to 22 rupees. That is the small matter before the court, for the reason, my lord. In order to connect the accused persons in the crime, my lord, the IO and the processes, they established that the previous night there was a quarrel, my lord, in order to bring the enmity between the parties, my lord. So far the case is concerned, my lord, except the family members, my lord, the PDOL 1 and PDOL 11 and 14, they claims to be the eyewitness to the occurrence, my lord. They are the wife and daughter of one of the deceased, my lord. Though they stated that they had seen the occurrence, my lord, there are evidence, my lord, itself show that there is no such witness present at this spot. They have stated that the occurrence taken place in the village road, my lord. And absolutely, they stated that there is no such person, independent witness present at this spot, my lord. Both the witnesses are interested for success of the prosecution case, my lord. The PDOL 15, my lord, one of the independent witness, my lord. So during course of investigation, in his 161 statement, the IO recorded a 161 statement about that witness. He stated that he had seen part of the alleged occurrence, so far assault part is concerned, my lord. But that witness, my lord, only one independent witness examined, that is PDOL 15, my lord, page 90 of my paper book. I know the accused persons as they are my co-villagers. I do not know anything about this case, but in his 161 statement, he categorically stated that he had seen part of the occurrence, my lord. I do not know anything about murder of the deceased, Anand Mahapatra and Thakur Mahapatra. I was not examined by the police in this case, my lord. This witness has not been declared hostile, my lord. The prosecution has not examined him, my lord. And he has, in his cross-examination, he stated that there is a temple named Matkani temple on the side of the bank of the canal. I have seen the house of the accused persons, who should be about a furlong away from the house of the accused persons. There are other houses on the road between Matkani temple and the house of the accused persons, but at a little distance. But the PDOL 11 and the PDOL 14, they claims to be the eyewitness occurrence, my lord. I want to place their evidence, my lord. Their evidence is very, my lord, is very much necessary for adjudication of this case, my lord. PDOL 11, my lord.
Kamini Mahapatra.
At page 73, my lord.
Yes.
The deceased Thakur Mahapatra was my husband, and the deceased Anand Mahapatra was his elder brother. I know all the accused persons in the dock. The occurrence took place about 2 years and 5 months back. On a Saturday, I asked Sita rupees 42 towards the credit taken from my shop. She replied that she would only pay rupees 22. At this time, the accused Sara, alias Sarathi, came there and without understanding anything, shouted at and abused. At this time, the accused Rajendra Mahapatra arrived there and asked to why and what money I was asking for. To this, my elder brother-in-law, Anand Mahapatra, in order to specify the matter, asked us to disburse without quarreling. At this, accused Rajendra Mahapatra told swearing and touching the ground that unless he did away with the lives of our entire family, he would have no name. On the next day morning, my husband was to water the land, and myself along with Damayanti, where Damayanti, another witness, my lord, Pedal 14, were behind him at the distance going to attend call of nature. Near Matkani Square, accused Raju was standing holding Kodi and seeing my husband abuse him, saying as to what money his wife was asking yesterday night. To this, my husband pleaded ignorance. At this, the accused Raju dealt the blow by means of a Kodi on the right side head of my husband. As a result of which, at this, myself, my daughter Damayanti rushed to the spot and made my husband stand holding him. At this time, the accused Rajendra arrived there holding a knife, and the accused Sara reached there holding a gupti. Thereafter, accused Dhul, who has been, my lord, who is during the course he expired, my lord, and Sagar has been acquitted, also reached at this spot. At this time, my elder brother-in-law, Anand Mahapatra, reached there, and all the accused persons hurling abuse started assaulting Anand Mahapatra. The accused Raju dealt blow by means of a Kodi on his head. Accused Rajendra stabbed with the knife, and the accused Sara dealt stab blow by means of a gupti. When myself and my daughter Damayanti tried to intervene, the accused Rajendra and Sara pushed us away. When my elder brother-in-law fell down, sustaining severe bleeding injuries, the accused Rajendra and Sara came near my husband and again started giving blows by means of a knife and a gupti. When I tried to intervene, the accused Sara gave a blow by means of a gupti, which caught my right hand palm. The cloth and blood of the accused persons were also bloodstained. At that time, other family members arrived there. The accused threw the Kodi there and saying that they had murdered my husband and elder brother-in-law, and they do away with the lives of the persons who would give evidence against them. They left towards the village. My husband and elder brother-in-law died at this spot. Cross-examination. The parents' house near Thuapalli. My parents' house is near Thuapalli. My marriage was about 20 years back. After marriage, I had come to village.
No, but is there anything significant? You read that part.
My lord. My lord, significant is, my lord, though the PW 11 stated that all the accused persons assaulted, my lord, the deceased persons, my lord. This witness, though she claims to be an eyewitness to the occurrence, she specifically not stated in her evidence that which accused responsible for which injury, my lord. One lungs injury, one died due to lungs injury, another died due to heart injury. That is the cause of death, my lord. Though there is other injuries are there, my lord, on the other part of the body, my lord. Two injuries are, my lord, the possible for cause of death, my lord. But she specifically not stated her evidence who caused that injury, my lord. That is not there, my lord. So, my lord, it is clear, crystal clear that she is not the eyewitness to the occurrence. She had not seen the occurrence, my lord.
No, your palm was cut.
My palm was cut, my lord. With that respect, my lord, though they have stated, my lord, that is my plea, defense plea from the starting of the case, my lord. That has been, my lord, created one, my lord. Only in order to keep the accused persons, my lord, there is long-term dispute between the parties, my lord. More in absence of only motive, my lord, for rupees 42, there is a quarrel in the previous night, my lord. And that respect, there is no such FIR laws, my lord. There is no such FIR laws before the police, my lord, in the previous night, my lord. And the daughter of the PW 11, my lord, PW 14, she is categorical stated her evidence that the another accused who has been acquitted, Sagar acquitted, he caught hold of one of the deceased, my lord. He has been relying same sort of evidence, my lord. He has been acquitted, my lord. The trial court, while relying same sort of evidence, he has acquitted, my lord. And my lord, another thing, they have stated that while submitting this, my lord, they are stated to be the natural witness and the eyewitness to the occurrence, my lord. But they stated that they are going to attend the call of nature on the date of occurrence. My lord, one of the DW, my lord, DW1, my lord, DW1 at page 109, my lord.
Yes.
I know all the accused person in the dock. The accused Sarathi Mahapatra is my daughter-in-law. That I wrongly mentioned, my lord. Accused Sagar Mahapatra is my uncle-in-law, and other are brother-in-laws. They all being the Kusan Puri, Thanapati Tikra. I am married since 11 years. Since my marriage, I must have visited my father's place 30 to 40 times. I have seen the Matkani temple in the village of the accused persons. I knew this is Thakur Mahapatra and Anand Mahapatra. I had also family relationship with them. Though through in my in-laws, the house of my in-laws and the deceased persons are adjacent. The temple is about 50 to 60 yards from their house. I had visited to the house of the deceased persons. They, very important, they had their latrines in their house. But in fact, their presence, my lord, that they are going to attend call-up lecture outside from their house, my lord, while they have seen the alleged occurrence, my lord. Even if they seen the alleged occurrence, there is no where they mention that they raise halla for the rescue of their husband, my lord. There are two persons, my lord. They have not raised halla so that the other people came there and rescued the deceased persons, my lord. They have nowhere mentioned in their evidence in chief that they raised halla for rescue of the deceased persons, my lord. And so also, my lord, it creates doubt as because the DW1, they have Latins in their house, my lord. And the question about attending call-up outside the house does not arise, my lord. That about this part of the evidence has not been demolished by the prosecution in the cross-examination, my lord, whether there is having any Latin or not, my lord.
No, just see that para 4.
My lord.
He has never gone to the body side.
My lord.
I have simply seen the frontage of their house. I cannot say about the body of the house.
My lord, my lord.
Usually toilets are in the rear only.
They have not, specific question has not been put to the
it does, sir.
Whether they
that song is answered. Just see,
my
I had visited their house within 5 years of my marriage.
My lord.
Read that.
Paragraph 4, my lord.
Yes.
I had gone to the house of the deceased persons 2 to 3 occasions being called by them as a son-in-law of the family. I cannot say on which day I had last visited their house. I can't since how many years I had gone not to their house. Not gone to their house. I had visited their house within 5 years of my marriage. I have simply seen the frontage of their house. I cannot say about the body of their house. It is not a fact that I am not acquainted with the village Thanapati Sikra.
So how will you know?
Specific word, the word itself, Latin, whether there is having there any Latin or not, that has not, though he is stated in the chief, my lord. Only stated the burial land, my lord. The nowadays, my lord, the Latin, all persons having Latin attached to the rooms, my lord, living rooms, my lord. That, my lord, this question not.
Anyway, all right.
My lord, another person, my lord, another part, my lord. The doctor, my lord. Period 14 is important, my lord. Period 14, my lord. I want to place the evidence of period 14. So far, I have not placed it correction, but I know all the accused person of the dog. This is Thakur Mahapatra, was my father. This is Anand Mahapatra, was my elder brother. On 19/8/2000, on a Saturday, my mother asked Sita Mahapatra for rupees 42 towards credit taken from our shop to the Sita. Same thing, my lord. He has stated same thing, my lord. I am reading out
cross-examination.
My lord. Relevant person, my lord. He has a in paragraph 2, my lord. Page 86.
Yes.
My lord, in middle, my lord, middle, after my lord, 1, 2, 3. The
seeing my elder father,
my lord,
accused Sagara.
My lord. Seeing my elder father, the accused Sagar, caught hold of his hand from behind and told to assault him, my lord. Though the PW 11 are not stated, but in fact, though she claimed to be an eyewitness, my lord, PW 14, my lord, she specifically stated that Sagar caught hold the one of the disease and told to assault him, my lord. That relying that part, my lord, when the trial court acquitted that accused, my lord, dismissing this witness, my lord. So these witnesses, both the witnesses who claims to be an eyewitness to the occurrence, my lord, they are so interested and inimical to the accused persons or appellants, my lord. These two witnesses are not the natural witnesses. They are not gone to that the particular time, my lord.
All right.
And our specifically that, my lord, the place of occurrence, my lord, not where the dead body was found, my lord. They brought the dead body to that place and implicated these accused persons in this case, my lord. And that happened, my lord. Another thing, my lord. The inquest report, my lord. But though not supplied to me, my lord, but inquest report, my lord, can be available with the LCR, my lord. There are 2 inquest reports, my lord. In column number 9, my lord, though it is stated that FIR arrested at about 9 a.m. Though that has been 9 a.m. that has been manipulated by the police, but admitting the fact that the FIR lost at about 9 a.m., my lord. But in fact, inquest at about 9:30 a.m., my lord. Both these person one. My lord, no, not available with me, my lord. Consider the fact, my lord. In the column number 9, my lord, there is not mentioned the name of the accused persons, my lord. Though the FIR was lost, my lord, they well aware about the fact that the petitioner, the appellants are the author of the crime, my lord. They have not mentioned there, my lord. It shows that the investigation is, my lord, had been not done in a proper manner, my lord. And when the inquest of both the dead bodies, my lord, made inquest, my lord. By the time, my lord, it is not known to none of the witnesses, and the PW 1 itself signed in the one of the inquest report, my lord. He has not mentioned alter a word, my lord. The IO not stated the same, my lord. So it creates doubt, my lord. If the PW 1 heard from the PW 11 that these persons are the assailants, my lord, why they have not mentioned the inquest report, both the inquest report, my lord. But the investigation, the faulty investigation, my investigation not carried proper manner, and in order to implicate the accused persons, they created another affair and submitted a report in that case, my lord. The IO himself, my lord. And the 2 witnesses, though claim the 2 of the witnesses, they claim to be an eyewitness to the occurrence, my lord. Their presence is not natural, and if the scrutinize their evidence, my lord, their evidence, my lord, not trustworthy, my lord, as because they are interested and the inimical to the deceased persons, my lord. Another thing, my lord, though the FIR drawn on 20th, my lord, the IO unable to explain why he keep the FIR for a period of 2 days, my lord.
All right.
Not sending to the court. All right. And other parts are there, my lord. And another chance may be given. Completion of I will go the law part, the point of the law, my lord. So, and that may be given.
Then we'll keep it on a Friday.
My lord. But tomorrow.
Tomorrow, I think reference will be there.
My lord. Next week, my lord.
Next week I am not available.
29th.
Next week.
28th.
I will not be available in that week. I'll go to Puducherry.
So 4th November.
Then
4th November. All right. We treat it as part 3rd, list on 4th November. All right.
Item 89.
I'm there for the respondent.
30th November.
Item number 90.
90 also, same date.
Item 91.
These are all different cases?
Yes,
My
these
lord,
are all
yes.
death reference.
No, they're different cases.
Yes, different.
So 90, you give a date of 6th December.
Right.
And 91, 14th December. All right. All right.